Good morning, everyone. While we're waiting for the forms, can I ask the teams to introduce themselves? Who's for the applicant? Who's the respondent? You are the applicant, and you are the respondents. Can I start from you? Please introduce yourselves.
As the court pleases. My name is Leah Unalena Sihule, and I'm with my co-counsels, Mr. Pilani Karabo, and also Ms. Riamogetswe Moekwa, and we are here for the applicants. Thank you.
The respondents.
Good day, justices. May it please the court. My name is Unisa and I'll be appearing on behalf of the respondents. I have my co-counsel, and Moashela.
Can I get the spelling for your second colleague? Is Clory?
C-O-R-L-Y.
C-O-R-L-Y. I've got Klassen and this gentleman.
Okay, Moashela. Moashela.
Okay. Thank you, teams.
Gwen, do you have an extra bit?
Applicants, we are ready when you are.
As the court pleases, we stand here before you today on behalf of the applicants to appeal on the matter that was decided on at the High Court regarding the unlawful forceful eviction of the Msenge community, herein referred to as the fifth applicants. We submit that the judgment of the High Court misinterpreted the importance of the applicants' legitimate contention, as they are the true owners of the land, and in such they cannot be evicted from their forefathers' home. We argue that the respondents violated the fifth applicant's human rights, and the president and the minister failed to protect them against the unlawful removals under the guise of the resettlement. And South Africa...
May I kindly interrupt you? We do not have your heads of argument, both parties.
Oh, sorry.
You may proceed, ma'am. We do have it now.
All right, thank you. South Africa has failed to comply with the international obligations necessitated by the African Union, the Union of the United Nations treaties, and the international customary law. In our submission, the respondents' approach to arbitrarily depriving the applicants of their right to property and should not be countenanced. Our submission on this case are structured as follows. First, we will deal with the factual background of this matter as well as the litigation history. The second one, we will submit why the court should grant leave to appeal. Third, we make submissions on the ownership of the land. Fourth, we make submission on the informal rights of the applicants to the land in terms of the relevant legislation. Fifth, we deal with the validity of the respondents' mining rights. Sixth, we submit that Section 6 of the interim arrangements and the relocation was not compiled with. Seventh, we submit that the respondents have not compiled with the constructive requirements of the Section 5, Issue 4C of the Mineral and Petroleum Resources Development Act of 28, 2002. 8, we make submission on the proper interpretation of Section 5 of the MPRDA. 9th, we submit that the respondents violated the applicant's human rights, the president and the ministers responsible for human settlements and the minerals resources and energy failed to protect the applicants against the unlawful removals. With this being said, if I'm of no further use to the court, I now hand over to my co-counsel, Mr. Pilani, to deal with the issues of jurisdiction, direct access, admission of Save the Culture as amicus curiae.
Thank you. You may proceed, Mr. Pilani.
As the court pleases, we come to this court using section 167(3)(b) of the Constitution, which states that the Constitutional Court may decide constitutional matters and any other matter if the Constitutional Court grants leave to appeal on the grounds that the matter raises arguable point of law of general public importance, which ought to be considered by this court. And it has the power to make the final decision as to whether the matter falls within its jurisdiction. We do so in line with Rule 19 to bring this appeal directly to the Constitutional Court. Furthermore, Section 167(6)(a) stipulates that the national legislation or the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with the leave of the Constitutional Court, to bring this matter directly. In this case, the fundamental rights have been infringed. The fundamental rights specifically of the Shitlinge Mshenge community, the fifth applicant in this case. We argue that human dignity under Section 10 of the Constitution have been violated by the respondents. In that, as pointed out in the case of Makwanyane, that the case relates to the balance between the right to life and the right to dignity. The judgment appropriately regards to the rights as mutually reinforcing, but places greater reliance on the prohibition against inhuman and degrading punishment. So therefore, in this case, the rights have been violated when the Shitlinge Mshenge community was removed from their area in a violent manner. Second, their freedom and the security right as enshrined in Section 12, subsection 1(e), were also violated by the fifth respondent when they were treated in an inhuman and degrading and also a cruel way. They were deprived of their freedom to religion, belief, opinion when the mineral rights holder, which is the fifth respondent in this case, wanted to exhume the graves of their ancestors to the city center without their consent. The fifth applicant was deprived of their right to property under Section 25 of the Constitution, which was applied contrary to the rule of general application. The first, fourth, and fifth, and sixth respondents have failed to take reasonable legislative measures within its available resources and foster conditions which enable citizens to gain access on the land on equitable basis. The fifth applicant was forcefully removed from their houses and were left stranded without shelter, food, in spite of their right to housing, Section 26, their socio-economic rights under Section 26 of the Constitution. Subsequently, the children's right. The children were also amongst the people who were forcefully removed. So their rights in terms of Section 28 were also in violation. Cultural rights and linguistic communities under Section 31 was also violated. I now move on to deal with the issue of direct appeal to this court.
Just interrupt you. Where in your heads are you at the moment?
I have started from page 11 and proceeded to page 13.
So you are currently on page 13.
As the court pleases.
Thank you, counsel.
Leave to appeal in this court. Leave to appeal in this court will be granted where the intended appeal raises constitutional matter and it is in the interest of justice for such leave to be granted. This court may also grant leave to appeal on the ground that the matter raises an arguable point of law of general importance which ought to be considered. Direct access is also contained in section 167(6) of the Constitution. We argue that this matter raises the constitutional matter and points of general importance in that the appeal raises the following constitutional matters of general importance between the parties relates to the proper interpretation of section 54 of the MPR in the light of the decision of the Supreme Court of Appeal in Jubet versus Miranda Mining Company 2010, which was decided in the Supreme Court of Appeal. This court is thus requested to provide a clarity on the correctness of the SA decision on Miranda in the light of the facts of the application. I now move to the issue of admission of Amicus curiae as contained in paragraph 60 of the heads.
Before you move, counsel, I just want us to entertain the issue of direct access. You mentioned the case that you've just referred us to. What are the submissions from that case that you want us to consider in making your argument?
Firstly, the cases that I decided, I cited.
I just want to help you. I'm referring to the last case you mentioned just now.
Oh, it was in relation to direct access.
I'm aware. My question is, what do you want us to consider from that case in persuasion of your argument for direct access?
As the court pleases, the case highlights that the interest of justice, when the matter is within the interest of justice and for public importance, the Constitutional Court has to take into consideration whether the matter that is brought within its purview falls within that section. Right.
Thank you. I also want us to entertain the scope for direct access. Basically, that case aligns with Section 167 of the Constitution.
As the court pleases.
Now, what precludes you or your client from referring this matter to the Supreme Court of Appeal? And I ask this because I'm aware that the Supreme Court of Appeal has jurisdiction to entertain any appeal or leave to appeal, even those including constitutional issues. So what presses your client to particularly approach this court and skip the Supreme Court of Appeal? Why should we not send you back to the Supreme Court of Appeal?
As the court pleases, your justices, we do so because of the gravitas of this matter and its agency. The fifth respondents have evicted the people of Chitanga Mshenge community, the fifth applicants. So now they are on the street. If the court cannot rule on this issue, then they will be disadvantaged without homes, shelter, and it also happens in the children. The children are also on the streets.
Understanding that submission, that you are saying the East Agency because there's women and children on the street, and you require an urgent intervention from this court, what precludes your client from obtaining the same relief at the same speed from the Supreme Court of Appeal?
As the court places, this is a constitutional matter, and also that when it goes to the Supreme Court of Appeal, it may need to be appealed to the Constitutional Court. Therefore, we need it to be decided at the Constitutional Court in order to ensure that the rights of the applicants are safeguarded.
Thank you, Counsel.
I now move on to deal with the issue of save the culture to be admitted as an amicus curiae. Subject to the rules of the Constitutional Court, Rule 10, it contains the procedure for the admission of amicus curiae. It says, any person interested in any matter before the court may, with the written consent of all parties in the matter before the court, given not later than the specified time in sub-rule, be admitted therein as an amicus curiae upon such terms and conditions and such rights and privilege as may be agreed upon in writing with all the parties before the court, as may be directed by the Chief Justice. We come to the court because Save the Culture have a documentary evidence and the video recordings, the audio recordings as well, that was taken during the day of the humiliation that the respondents has made on the people of Sitlenga Mshenge community. Therefore, the amicus curiae will help the court in this regard to advance evidence that the court will not otherwise get. Hence, we ask the admission of amicus curiae. We have noted that the respondents are opposed to the admission of amicus curiae. However, Sub-Rule 4 says that when the consent from the other party has not been secured, the party that is seeking to be admitted has to write a letter to the Chief Justice in order to make the final decision on a matter as to whether the admission of amicus curiae will be effected or not. It's in terms of that we want safe culture to be admitted. If I am of no further use to the court, I now hand over to my co-counsel, Ms. Moekwa.
You may proceed, ma'am.
As the court pleases your justices, my name is Resumption Moekwa. May I use the pulpit or it's okay?
That's what I wanted to ask, to say, why are you not addressing us from the pulpit? Or is it not done in this room? You may come forward if you wish.
As the court pleases your justices, we submit that the removal and resettlement of the fifth applicant was inconsistent with Section 25, subsection 1 of the Constitution. In this case, the fifth applicant was deprived the right to property in that the seventh respondent forcefully removed the applicants from their land. The Shiklini Msenge community, which included the people included the children, the elderly, and the disabled. According to Section 25, subsection 1 of the Constitution, any deprivation of property must be authorized by the law of general application. The law must not permit arbitrary deprivation of property. Section 25, subsection 2 further states that property may only be expropriated for purpose of the public interest. We submit that the mining operations were not done in the public's interest, as it did not comply with the Constitution, the rules, and the obligations governing the seventh applicant. One of the express provisions of the seventh applicant. One of the express provisions of the seventh applicant is that any decision taken which concerns the community to live in harmony, there ought to be 2 or 4 members of the traditional council, including the leader of the ACC. However, in this case, Mr. Nkopodi, who's the member of the ACC, took consent unilaterally, which excluded the community and was inconsistent with Schedule 1, Subsection 2 of the Traditional and Cohesion Leadership Act 3 of 2019, which states that the members must function in good faith, act in the interest of the public, and not use the power of office to gain personally or not in the interest of the public. We further argue that the Minister of Mineral Resources failed to exercise his power in terms of Section 47 of the Minerals, Petroleum and Resources Development Act 28 of 2002 to suspend or cancel the mining right. As we move to the issue of the obligations of the ministers regarding the human dignity, culture, religious, and linguistic communities. The South African government and ministers have obligations regarding the rights to human dignity on page 16 of the Heads of Argument, Your Justices. It has the obligation regarding the rights to human dignity, cultural, religious, and linguistic communities, as well as certain limitations. Protection of human dignity. The obligation states that the government and the ministers must protect and promote the inherent dignity of all individuals. They are responsible for ensuring that no person is subjected to torture, cruel, inhuman, or degrading treatment or punishment. The cultural right states that the government and ministers are obliged to respect, protect, promote, and fulfill the cultural rights of individuals and communities. In page 7 of the Heads of Argument, the applicant's rights in terms of IPILRA, which is the interim, excuse me, Your Justices, in terms of IPILRA, which is the Interim Protection of Human Land Rights Act 31 of 1996 states that Section 1 of the IPILRA Act Section 1 of the IPILRA Act states that any use of land in terms of the tribal and customary or indigenous law or practice, the custom, usage, or administrative practice in particular area or community where the land in question at any time vested the South African development. Section 2 of the IPILRA deals with the deprivation of informal land rights subject to the provisions of subsection 1 of the Section 2 of the IPILRA and the provisions of Expropriation Act 1975, Act number 63 of 1975, or any other law which provides for the expropriation of land rights in land or rights in land. No person may be deprived of any informal right to land without his or her consent. Where land is held on a communal basis, a person may subject to subsection 4 be deprived of such land in land accordance with custom and usage of the community. If I may be of no use to the court, Your Justices, I may now hand over to my co-counsel, Leah Sehule.
You may proceed, Mr. Bole. Thank you, Counsel.
As the court pleases, please refer to page 18 in your Heads of Argument. We'll be dealing with the issue of the constitutional obligations of the Eastern Cape with regard to the provisions of alternative housing. Now, in this matter, the respondents actually, like we've mentioned, that it has actually infringed the rights of the applicants. The fifth applicants are now forcefully removed from their forefathers' home where they have land and also made provisions to make a living from that place for more than 200 years. So they've been forcefully removed from their homes and now left stranded on the streets. Now, the question is, have the respondent actually taken into consideration that moving the applicants to the city center, will it be, will the applicants be able to sustain their livelihood in the city? They have never provided us with any plan, their environmental plan, on how the applicants will be able to sustain that life. Who's gonna be taking the children to school, the expensive schools that will be there? Who will be taking care of their grants in terms of transportation or anything of that sort? I know the respondents will say they actually wanted to develop our community, but have they ever thought of the people who have been in these informal settlements to at least provide us with an environment that is actually similar, because they cannot afford the living expenses daily? Now, with this being said, I'll move on to issue 6 of the protection rights of the children. These children are of paramount importance. These children don't have a say, and they actually get consent from their parents. So in as much as your children are on the streets, they're embarrassed and evicted from their houses, nobody is there to even protect them. Even their elderly parents, who are also, whether they're elderly, whether they are disabled, and you actually got the audacity to push them out without thinking of the consequences and the emotional strain it actually provides to them. With this being said, the relevance of the protection of the children's rights in Section 28 of the Constitution guarantees the rights of children, emphasizing their right to family care, basic nutrition, education, and protection from maltreatment and abuse or neglect. Furthermore, the parents were not able to actually give that support to their kids, as they are also much in the streets. The court, like I've mentioned, eviction is a sign of failure, and it is questionable whether eviction can be the most effective or ideal response to the difficulties faced by the family with children, for either economic and social moral perspective. With this being said, we pray that the Honorable Court rules in our favor by returning the community to their ancestral place, which will be the best interest of both the children and the families who are out in the streets. We submit that Save the Culture be submitted, as it will be of assistance to the court, as it has advised the courts in all the South African democratic countries. And we also submit that we submit that the conventions of the Save the Culture's intimate knowledge of the issues that have led to the conflict, coupled with their vast collection of evidence, would be of assistance to the court with or whether they seek order dismissing the response submission, that admitting to Save the Culture would be a waste of time and court's resources. In this, it is on the basis of the applicants, we submit that this application should succeed and cost should be awarded in favor of the applicants, including the cost of the 3 council. If the court pleases, thank you.
Before you sit down, I just have a question for you, Council Sehole. Are we dealing here with an issue of eviction or removal and resettlement of this community? Were they evicted or they were removed?
They were forcefully removed from their home.
So you know the difference between eviction and forceful removal?
Yes.
Thank you. You may hand over to your colleague. Okay, I will hand over to my 2 justices. I'm not sure if they have a question for you. Either of you who wants to respond will come to the podium. Thank you, justices.
Thank you very much, my sister. I have a few questions. Any of you may feel free to respond to. One, it's in respect of the Amicus curiae, Save the Culture, which you've argued that we must admit. We are aware from the facts that Save the Culture is not registered in South Africa. What should we do with that?
Argue that the admission of Save the Culture as amicus, was there no other way to lead the evidence? I don't think I've heard you quite well as to the necessity. So I think the question becomes twofold. The fact that they're not registered in the country, and number two, I don't think I've heard you well with regards to really the need for them as part of the proceedings. Was there no other means to secure the evidence?
As the court pleases your justices, in terms of section 88 of the Constitution dealing with the enforcement of rights, it says anyone listed in this section has the right to approach a competent court alleging that a right in the Bill of Rights has been infringed. The person who may approach the court are anyone acting in the public interest and any association acting in the interest of its members. In terms of the rules of the Constitutional Court, rule number 9, it coincides with paragraph D in section 88 of the Constitution, in that an association acting in the interest of its members may bring the matter to the Constitutional Court. Is section 38?
88.
38. 38. Paragraph E. And another question that was raised by the justices, Save the Culture is the one who took the video recordings and the audio at the time when the incident has happened. Therefore, it will be important for it to come and testify before the court what is it that they saw. That evidence will be helpful to the court. It will bring the evidence or the information that the court, if not admitted, it would not have sight of. As the court pleases.
Thank you, Counsel. I'm not sure if my justices have questions for you.
Just one more question for, I think it was Ria Mokhetsi, Counsel. You referred us to your heads of argument where you made various submissions in respect of the Act. I think it is on page 7 of your heads of argument, the IPILRA. Having read your heads, and having listened to your submissions, I understood you have reiterated the provisions of the Act, but I did not quite get what you wanted us to do with those provisions. If you could briefly just clarify, what should we do?
As the court pleases your justices, as noted in the case that the fifth applicant were removed, and according to section 54, subsection 1 of the MPRDA, consent is needed from the community or the occupiers of the land. Mr. Nkopodi, as the member of the ACC, the fifth respondent applicant, the seventh applicant only gave consent without a mandate from the community. Therefore, section 54, subsection 1A was violated in terms of the MPRDA. As the court pleases your justices.
Thank you.
Thank Thank you, councils. We will now hand over to the respondents.
Good day, Justices. May it please the Court. My name is Lungile Khumalo, and I am appearing on behalf of the respondents. The respondent in this case emphasized that this case is not an issue involving the applicant's constitutional rights and maintain that they have consistently acted in good faith throughout the entire dilemma. Justices, I shall be dealing with jurisdiction, urgency, and direct access to this constitutional court. Rule 6, subsection 12 of the Uniform Court Rules states that, or rather deals with the urgent application and specifies when the outlined formalities and procedures may be waived due to urgency. A court may do so as it sees fit, but the rule requires the applicant to explicitly state the circumstances that make the matter urgently and why it could not be done in an ordinary course. In Dynamic Sisters Trading Limited and another versus Nedbank Limited, the court recently emphasized the importance of providing viable reasons for dispensing with the formalities of an application proceedings when instituting an urgent application as set out in Rule 12, subsection 12 of the Uniform Court Rules. This decision serves as a reminder that urgency is always evaluated objectively and that self-created urgency falls far short of meeting the requirements of Rule 12, subsection 12. Rule 12, subsection 12 ensures that justice is not delayed in situation where waiting for regular legal process could have serious consequences. Keeping this in mind, the applicant's adherence to normal court procedures will not place them in any disastrous circumstances because the 7th respondent have ensured shelter, safety, a school for the community, and anything else the community requires can be provided for through compensation or other alternatives. The respondents then maintain that this is not an urgent application because the applicant self-created urgency. Can I move on to jurisdiction? According to Section 167, subsection 3 of the Constitution of South Africa, the Constitutional Court states that it is the highest court in all constitutional matters and has the authority to decide only constitutional matters and related issues, and makes the final decision on whether a matter is constitutional or related to a constitutional decision. The Constitutional Court decides whether the matter is within its jurisdiction. This is not a constitutional issue. Furthermore, it is debatable whether the matter raises an arguable point of law, which would give this honorable court to hear it. The issues in dispute do not concern the first to 6 applicants' fundamental rights. Although it affects the applicant's fundamental rights to housing, children's rights, human dignity, and religious and linguistic freedoms. The constitutional fundamental rights cited by the applicants were not the primary focus. The main focus was the ACC's constitutional disputes and the lack of authority, and it is a separate matter. Throughout the proceedings, the respondents have acted on the assumption that the community has given permission on the respondents to begin mining activities and the community to be relocated to the nearest city center. May I proceed to direct access? This court considered Section 167 of the Constitution in the case of EFF versus Gordon. This court stated that not all litigants who apply to this court will be permitted to do so, that this court is mandated by Section 167, subsection 3, 1 and 2. Paragraph 39 of the EFF versus Gordon, this court stated, open quote, "This court has cautioned that it will not grant leave to appeal merely because an applicant is aggrieved by lowest court's application of the law. In Makaya, it was observed that, open quote, this court has refused to entertain appeals that seek to challenge only factual findings or the incorrect application of the law by the lower courts. Thus, for this court to adjudicate on the merits of a matter, that matter must not merely involve the application of an uncontroversial legal test to the facts," close quotes. Similarly, in Jiba, this court held that the application of an established legal test does not raise an arguable point of law which would ground our jurisdiction. Close quote. In light of the foregoing, as demonstrated in the Gordon case, this court should decline to hear the case because the applicant is merely challenging the High Court's correct application of the law. The legal principles do not raise an arguable point in this case. If justices do not have any further questions, may I hand over to my co-counsel to
ascend the podium. I just have one question for you. I hear you telling this court that this is not a human rights issue, but a contractual issue. What do you have to say to the information that was provided to this court that your clients hired a private company, forceful removers, to remove the community? Isn't that removal on its own, does it not raise a human rights issue?
A good question. My justices, we are saying that from the beginning of the proceedings to relocate the community to the nearest city center, up until that moment, we followed the right procedures. However,
yes, Counsel, but I just want you to I want to understand the issue of jurisdiction. As you said, this court can only entertain this matter if we find that there are human rights violations. So I just want to find out from you as a respondent, by you hiring a private company to assist in these forceful removers, according to you, do we not find any issues of human rights violations in there?
The seventh respondent does accept that they have evicted the applicants unlawfully. However, they have followed due procedures throughout the whole ordeal. They are accepting that, yes, that part was wrong, or rather unlawful.
Oh, and another issue, I heard you referring us to uniform rules.
Yes.
Have you had regard to the rules of the Constitutional Court?
Can you please rephrase your question?
The uniform rule 6,
yes, subsection
12 that you referred us to, the one
yes,
dealing with agency.
Yes.
It's a High Court rule. Have
yes,
you had regard to the rules of the Constitutional Court, especially dealing with agency?
Yes, but I didn't put it on my heads of arguments unless the courts may allow me to refer to that.
No, I think my question is answered. I will leave to my justices.
Okay.
Thank you. I will stick to my sister's question on the aspect of agency. You
yes,
do refer to Rule 612 of the Uniform Rules of Court, but I know due to your hasty approach, you referred to it also as Rule 12, but it is Rule 612. Now,
I did.
You speak of, you mentioned the case of Dynamic Sisters.
Yes.
However, you don't give us a proper context where we need to infer that this agency that we sit with today, or as presented by the applicants, is self-created. Can you just dwell briefly on this self-created agency that the court should not entertain?
Okay,
just briefly.
Briefly. I don't think I can
Why would you say it's a self-created agency when it borders on the infringement of imperative human rights? Why would you say it's self-created? They're not removing themselves. Why do you say it's self-created?
When it comes to the human rights that they say they alleged the 7th applicant, or rather the 8th applicant, the 8th respondent has violated, we are saying yes, we have done that. However, this is not a constitutional matter. It is still can I refer to my heads of arguments?
Please.
It's basically a different case. Sorry, can I?
Are you saying the matter is not a constitutional matter?
Yes. This is not a constitutional matter, as we are not necessarily dealing with, we have violated, the 7th respondent has violated the applicant's fundamental human rights in a way, not directly so.
Thank you, Ms. Kumalo.
Have I answered your question?
Thank you, Ms. Kumalo, yes.
Yes, you may call your second counsel.
As it pleases the court justices, I'm going to be speaking about the constitutionality of the forceful removal of the community and the relocation and resettlement of them. This would we find on page 8 of the heads of argument at paragraph 25. It will be starting there. Iron Africa Mining Corporate complied with all the legislative and policy requirements to obtaining the prospecting rights in order to conduct prospecting operations in the Bokong region of the Eastern Cape, as per Section 16 of the Mineral and Petroleum Resources Development Act. Once the prospecting phase was concluded and the results indicated the desirable volume of iron ore reserves that are located in the Bokong region, the legal department of the IAMC initiated the formal process to apply for the mining permit required by Section 22 of the Mineral Petroleum Resources Development Act. All legislative requirements were complied with. The IAMC was granted a mining right in terms of Section 23. In terms of Section 22, subsection 4B of the Mineral Petroleum Resources Development Act, it was expected of the IAMC to notify and consult with the interested and affected parties. As per the facts of the case, the community's affairs are headed by the African Community Council, the ACC. Thus, the ACC represents the community and is the voice of the community. IAMC adhered to the requirements set out in the Section 22, subsection 4B by the Mineral Petroleum Development Act, Resources Development Act, by approaching the ACC in order to facilitate consultation agreements or engagements in preparation for the desired mining operations to commence. The requirements were met, and Ms. Nkapodi, who was acting chairperson at the time of the ACC, gave consent for the mining operations to commence and the conditions that need to be met in order for the community to be moved. The community was going to be provided with adequate housing when moving to the nearest city centre. Section 25, subsection 9 of the Constitution calls for legislation that should be enacted by Parliament, and this is known as the Interim Protection of Informal Land Rights Act. Section 2, subsection 4, holds that for the purpose of this section, the custom and usage of the community shall be deemed to include the principle that a decision to dispose of any such right may only be taken by the majority of the holders of such a right, present or represented at a meeting, convened for the purpose of considering such a proposal. The community was given a reasonable opportunity to participate through the consultative process with the ACC. The IAMC authorities had the understanding that these processes were by the comments and sentiments of the community as well as that of the ACC. If there are no further questions, my Justice, may I please proceed to the obligations of the South African government?
You may proceed.
The South African government did not fail in their obligations towards the community in regard to Section 10 of the Constitution. The community's right to dignity was not infringed upon. They were still respectfully removed and relocated to the nearest city centre.
Did you say peacefully?
Well, they were removed. I said respectfully, not peacefully.
Go.
Sorry. As for Section 31, subsection 1 of the Constitution relating to cultural, religious and linguistic communities, it states that persons belonging to a cultural, religious and linguistic community may not be denied the right, with other members of that community, to enjoy their culture, practice their religion and use their language. As far as the IMCA and the respondents are concerned, they did not infringe upon this right of the community. The community's right to practice their religion and to enjoy their culture has not been denied by moving them to the city centre. It does not influence their ability to train and practice their traditions, as they will still have access to water sources, such as they use it for a spiritual element of connection to the ancestors. They have also buried their loved ones on a communal cemetery grounds, and visiting them is an integral part of their culture and traditional practices. And that is noted by the respondents. That is why, by exhuming the remains and relocating them to the nearest city centre graveyard does not violate the premise of Section 31, subsection 1 of the Constitution. Furthermore, the community may communicate with the ancestors and explain to them why they are going to be exhumed and also where the new final resting place will be. As for the cost, the respondents have said that they will cover the costs relating to that. As it pleases the court, I will now be dealing with I will hand over to my co-counsel and I will come back to deal with the conclusion. If there are no further questions for justices.
Counsel has, my fellow justice has a question for you.
Yeah, just one question before you seat counsel.
Yes, Justice.
You seem to be arguing, or rather it seems to be your argument that proper processes were followed and that your client negotiated the position with Mr. Nkopodi, whom you seem to be suggesting that was representing the community. We have it on the facts that the community has refused, or rather the community has stated that they have not mandated Mr. Nkopodi to act on their behalf. What measures did you take to verify the mandate of Mr. Nkopodi? Two, in what capacity was your client negotiating with Mr. Nkopodi on behalf of the client in absence of the mandate?
Okay. So, Justice, in regard to that, Mr. Nkopodi was acting chairperson of the ACC at the time of the negotiations or the last negotiations. Thus, he was in a place of authority. The respondents do not know the inner workings of the ACC's constitution, and they only know what they are being represented by as the ACC. Thus, Mr. Nkopodi giving them the illusion that he was acting as acting as the chairperson, they still rightfully engaged with Mr. Nkopodi as acting chairperson because he was in an authoritative position.
You say that he created an illusion that he was acting on behalf of the community, and that's what your client acted on. Now that the facts have come to light and the community has made it clear that Mr. Nkopodi did not have the mandate, what is your position?
Justice, I think it is submitted to the court that should be taken up on a whole other case, since the inner workings of the ACC and the community does not concern the respondents.
Well, I guess my question is the agreement between your client and Mr. Nkopodi valid?
As far as we are concerned, it is a valid argument since he was an acting chairperson of the ACC.
Meaning, since you perceived him to be?
Yes.
He was not on the facts we have.
But that is a different, as far as the respondents are concerned, if that was a different case, or the applicants should take that up as a different case against Mr. Nkopodi for not being in a lawful position.
Thank you, Counsel.
As it pleases the court.
Counsel, before you sit down, I just want to follow up on my earlier question. I think my question was that, did you say they were peacefully removed, and your response was that they were respectfully removed?
Yes.
So I just want to make a follow-up on that. On paragraph 32 of your heads of argument, you informed this court that the community was going to be provided with adequate housing when moving to the city center. However, there are facts presented to this court where we are told that as a result of this forceful removal, the community was left stranded without shelter, food, and water. How then were you going to ensure that you're providing them with housing if, as a result of your forceful removals, now they are homeless?
So the community was going to provide with adequate housing.
Where is
As
the
per
housing now that they are homeless and without a shelter now? Where is that housing?
I suppose it is still there, but the community refused to move to that adequate housing that was provided to them by the respondents.
Thank you.
Thank you, Justices. As it pleases the court.
As it pleases the court, my justices, my name is Moashera. I will be dealing with issue 5, 6, and 7, which is the constitutional obligation of the Eastern Cape and the protection of children's rights and the admission of Amicus curiae. Having adequate housing is a fundamental right protected by the Constitution. If we take a look at section 26 of the Constitution, it provides that, specifically section 26 to subsection 1 to 3, it provides that everyone has the right to access adequate housing, and that the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. Subsection 3 says no one may be deprived or be evicted from their home without a court order made after considering all circumstances. Now, we submit that the Eastern Cape government is obligated to provide housing when it is only within its available resources. That is why the Housing Act was introduced. If we look at section 7, subsection 1 of the Housing Act, it provides that every provincial government must do everything in its powers to promote and facilitate the provision of adequate housing in its province, that is within its national housing policy. The Eastern Cape has obligations, a constitutional obligation to provide alternative housing in accordance to section 26, subsection 2 of the Constitution. But besides that, the IMC made means to ensure that the community is relocated to the nearest city center. So irrespective of who the applicant is, we still submit that an eviction application will still involve a two-based inquiry. That will include the court considering what it is just inequitable, this court considering what is just inequitable as exercised in its wider discretion. It is submitted that the finding that the Msenge community did not have consent to occupy the land in question should be sustained in applicable of all relevant principles and evidence presented. If my justices, please, may I please move to the protection of human rights? Section 20.
Sorry, before you move, I just want you to repeat your last statement. Are you saying this community did not have the consent to stay in their land where they're being forcefully removed?
Yes.
You may proceed.
Section 28, subsection 1, paragraph B, subparagraph 2, subparagraph C states that every child has the right to family care, parental care, and to appropriate alternative care when removed from a family environment to basic nutrition, shelter, basic service, or social services. Now, we do not contend that housing is a basic human right and that children have the right to live in a safe environment. Hence, we provided the community with adequate accommodation. With that being said, we humbly submit that the relocating of this community or relocation of this community to the nearest city center while they await their new permanent relocation or permanent home will result in better advancement. Better advancement is such as means of better infrastructures, education, school, and access to healthcare on time in the city location or centers, as reason being that there is development of infrastructures, such as schools, access to health care in the city locations, as they are often advanced compared to the land in contention. If the court may allow me, I may please proceed to Amicus.
Yes, you may proceed, Counsel.
Allowing Safe for Culture to be admitted as Amicus before this court will be a complete waste of time and court's resources. If we look at the requirements of admission of Amicus, we can see that Safe for Culture as a party wishing to be admitted as Amicus curiae was unable to meet these requirements because Safe for Culture as an applicant to be admitted as Amicus, they failed to briefly describe their interest in this proceeding. They failed to briefly and succinctly set out submissions which it wishes to advance. They failed to set out relevance of its submission in the current proceedings. They failed to set out reasons for believing that they are going to advance submissions that are different from those of the parties, the current parties that are in contention. According to the Constitutional Court Rule or 2003, application to be admitted as Amicus should not be made not less than 5 days. Also, taking into consideration that the fact that the Amicus or the Safe for Culture is an NGO, it's unregistered here in South Africa. So it is not recognized. So allowing them to come as Amicus before this court will be a waste of the court's resources and time. Even if this evidence is not presented before this court, it will not deprive the court of information that is relevant in assessing the so-called presumed or assumed wrongfulness. The Safe for Culture proposes to lead the state or the applicants, the state of the applicant's knowledge about the presentation of customary law and tradition, and the tradition, it will not assist the court in determining whether any kind of harm would have assumed or was foreseeable in the Shisini Msenge community. We thereby humbly submit that although at any event this court has a broadened discretion of determining the terms and conditions in which the amicus may be admitted, and as it is on its own, it has its own inherent jurisdiction on regulating its own proceedings, while on the other hand, ensuring that there is no duplication of trial, we submit that even if the evidence is not presented, this court will not be deprived of information relevant to us, to the assessing of the assumed wrongfulness from our client's eviction. In these circumstances, we submit that a proper case has been made for a non-admission of Save the Culture as amicus. May I please ask for my clients to do the closing arguments if you don't have questions.
Before you go, Counsel,
Yes.
allow me to take you back to page 11 of your heads of argument, the constitutional obligations of the Eastern Cape province. That's on page 11, starting from page 39. Please just go with me to the two judgments that you mentioned in paragraph 43.
In paragraph 43.
You make reference in your heads of Rademeier as well as Grootboom.
Yes.
Now, what do you want this court to take from those judgments in light of the facts of this particular given case? And can you also tie that in with the eviction process that has taken place in these circumstances? What is the law? What is the law where Grootboom and Rademeier are concerned? And straight to paragraph 44. What are you saying in paragraph 44 exactly?
Okay, thank you for that question. Now, what I will start by telling the court what this case dealt with. The case of Rademeier dealt with the issue of vicarious liability.
Please keep your mic up.
Okay, apologies. It deals with the case of vicarious liability, and then also the case of government of the Republic of South Africa versus Grootboom. It dealt with the state obligation with regards to the provision of the adequate housing. Now, what I want this court to take in light is the fact that, as far as the facts are concerned, the respondents concerned in this case are not bound to provide accommodation. This is because if we look at paragraph 44, it provides that as far as an eviction application concerns an applicant who is a private person, it is tried. That is, it is beyond dispute that an obligation does not exist. But whether such a private person or entity, but whether such an applicant is a private person or entity, it does not at any stage absolve the local government from providing alternative accommodation. So what we are saying that even though it was not our responsibility in providing the accommodation, we made means while we are awaiting for the local government to provide them for the permanent accommodation.
Counsel, just briefly.
Yes.
Your colleague stood there, and in the beginning, your colleague stood there and said to us, we don't have jurisdiction, or the matter does not find jurisdiction in this court. And her basis was because this is not a constitutional matter. But it seems throughout your argument, you are trying to convince us that you've complied with Section 26 of the Constitution, Section 28 of the Constitution, you are arguing your compliance with the Constitution. In other words, your arguments are around the fact that there are genuine constitutional issues in this matter. What should we make of your colleague's argument that this matter is not a constitutional matter, when you have spent the entire time you had convincing us of your compliance with the Constitution?
What we should make of our arguments is the fact that this application it should not concern constitutional matters, because we have, as the mining company, tried to exhaust the constitutional constitutional obligations way before. So the applicants are bringing the case of constitutionality, while we have already managed, tried to deal with them. In that case, we are trying to submit to this court that we should only focus on the issue of the relocation and also the mining right in that case, if it makes sense.
I know in the interest of time, so you say this is it is a constitutional matter.
It can be a constitutional matter depending on if it is viewed in that light. It can be.
All right. Thank you, Counsel.
Thank you, Kat. I had further questions, but I will allow your colleague to finish. Counsel, your time is up. Just briefly summarize the issues.
It is respectfully submitted before the court that this appeal not be granted. That it is also respectfully submitted that the community respect the relocation settlement and move to the relocation site that was provided by the IAMC. It is also submitted before the court that the consideration of the admission of Save the Culture as an Amicus curiae will be a waste of time. It is also submitted to the court that to strike down the application for urgency, and then finally it is submitted to the court that the application should be dismissed with cost, as it pleases the court.
Applicant, do you have anything in rebuttal? How much time do you allow them? Yes, you may.
As the court pleases your justices, on the issue of consent, Section 5, subsection 4C of the MPRDA states that there should be consultations with the occupants or the lawful occupants of the land. However, Mr. Nkopodi consented unilaterally and did not exclude the community, which violated Schedule 1, subsection 2 of the Traditional and Quaysand Leadership Act 3 of 2019. Furthermore, Section 211 and 212 states that customary law may be applied. Leadership roles of traditional leadership should be recognized. Subsection 2 of 212 to deal with matters relating to traditional leaders, the role of traditional leaders, customary law, and the customs of community observing a system of customary law. should be national or provincial legislation. National legislation may establish a council of traditional leaders. Furthermore, the respondents may not depend on Section 26 of the Constitution because there was no court order granted to them in order to evict. Where relocation is unavoidable, it should be based on the principle of minimal disruptions to the affected persons, to relocating people to a site as close as possible to the existing settlement. However, the Shiklenim Senga community is being relocated to the city center. How are they going to go to the grave sites and talk to their ancestors like the respondents have mentioned? Furthermore, the relocation settlement states that in page 10 of the heads of argument, a relocation strategy should be developed in collaboration with the community. On paragraph 39 of the heads of argument. The introduction of the case states that we are striking a balance between a democratic and a capitalist nation. However, the human rights, the fundamental human rights of the Senge community were violated. How do you expect that the striking of the balance between the two scales were succeeded? And furthermore, in paragraph 2.1 of the case, it states that Mr. Nkopodi was never given a mandate to go and represent the whole Shiklenim Senga community, as stated in the case that there should be a leader, 2 or 4 members of the council. As the court pleases your justices, thank you.
Thank you. Court adjourns.
You may be seated. Good morning. It is the 13th day of March 2024. We are here in the matter, case number 001 of 2023, in the matter between Themba Maluleka and others versus the President of South Africa and others. Will counsel for the applicants please introduce their team and proceed with the matter?
Good day, Justices. My name is Letabo Mola. I respectfully confirm my appearance on the behalf of the appellant, alongside my co-counsel, Ms. Litswane and Ms. Jaji.
Thank you, Ms. Mola. You said your first name is, your initial is L? And the counsel, your initial and surname?
Ms. Lenzwane.
Your initial and surname?
Lenzwane. ML.
ML Litswane.
Yes.
Thank you.
How do you spell your name?
LENTSOANE.
Thank you.
And counsel?
Jaji MPB.
MPB.
How do you spell your name?
TGR.
And the respondents, will you kindly introduce yourselves?
As the court pleases, my name is Leah Onalina Sehole. Initials is L-O Sehole. S-E-H-O-O-L-E. With me is my co-counsel, Mr. Karabo Pilani, and Ms. Riamogetswe Moekwe. Moekwa. Oh, Riamogetswe Moekwa. And represent the respondents.
Thank you, counsel. Applicants, you may proceed. Please just also take cognizance of the time and make all attempts to be brief in your submissions so that we also have enough time to engage. Thank you.
Okay. Good day, my Justices. My name is Letabo Mola, and I respectfully confirm my appearance on the behalf of the appellant alongside my co-counsel, Ms. Lintwane and Ms. Jaji. I will be dealing with issue 1 to 3, direct access to the Constitutional Court, jurisdiction before the court, and Lucas Dundee. If the court pleases, may I start addressing my issues?
You may proceed, ma'am.
Turning to my first point, this court has jurisdiction to entertain this matter. Section 167, subsection 3 of the Constitution, as it is infringed, we should raise matters of constitutional issues in this court. Forceful removers came upon the community and conducted a forceful removal of the Shikini community, including the elderly, disabled, livestock, and children. As a result, they were left homeless without shelter, food, and water. While they were doing so, their intrinsic worth, which is equated to human dignity, was eroded. Section 10 of the Constitution, which is human dignity, was eroded in the process. And we believe as the appellants that human dignity ought to be protected because it's a non-degradable right, eternally so. Section 30, subsection 31 of the Constitution states that everyone has the right to use language and make practices of their own choices in terms of culture and religion. It's also provided for the recognition and protection of customary law. The exhuming of ancestors will leave the Shikenim pupil emotionally and psychologically affected because it carries a sentimental value. Not only that, grave sites are known to be an integral part of cultural and traditional practices. Yes, Justice?
You said to us you are going to deal with jurisdiction, and now you're telling us about the right to human dignity and the right to culture, so on and so forth. What is the relevance between that and jurisdiction?
The reason I'm dealing with human dignity culture, it's me trying to make the demonstration of how we will try and apply or try and help you grant the jurisdiction in our favor. So the reason I'm not starting directly from jurisdiction and I'm starting from here is because I'm trying to demonstrate the merits of the case until we get to the jurisdiction part. So I will eventually deal with it, but I've already started.
Okay.
Okay. The proximity of rivers and ravines makes it possible to use water as a spiritual element to connect with the ancestors. Should the Shikenim people be relocated to a city center, it will make it difficult for them to connect with their ancestors. The children were unable to go to school because they were left homeless in the streets, violating Section 29, subsection 1 of the Constitution, which states that everyone has a basic right to education. Not only that, the first applicant, Temba Malulega and Rosalind Daiko, which used the little income that was generated through subsistence farming, won't be able to afford to get an education because that land now has been used, they have been forcefully removed and they're homeless. However, should the court believe that the submissions I've made regarding constitutional issues are not sufficient, we would love to make the second submission that we believe it's in the interest of justice that this court hears the matter. It is in the interest of justice because people are left without food, without access to water and shelter. But on the other hand, it prejudices the Shikenim people community because the safety of the vulnerable, such as children, women, elderly, and disabled, are at threat. The demolition of property is also unconstitutional. The matter is urgent because as the appellant are left homeless to fend for themselves, where they're subjected to unfavorable weather conditions, and as a result, this might be a threat to the right of life, violating a non-degradable right that ought to be protected. The matter is also urgent because we as the appellants don't have the time and money to follow the apex of courts. Should we make our way to the Supreme Court of Appeal and the judgment that is granted in our favor we're dissatisfied, by the time we make our way to the Constitutional Court, the appellant would be severely traumatized, also sick, but not only that, majority of them would have died on the way. We submit that in this court we have jurisdiction because of that. If justices don't have any questions, I would love to proceed to direct access to this Constitutional Court.
Please proceed.
We submit in terms of Section 100, subsection 2, that we should be granted direct access to this court. We respectfully plead to be granted direct access in terms of Rule 17, subsection 1, because we believe our matter is of exceptional circumstances, agency, and it's of great public importance because the community has no shelter or food, which are basic essentials to survive. They are subjected to unfavorable weather conditions. Children are highly vulnerable to abuse, exploitation, addiction, and crime. The Supreme Court of Appeal can hear the matter. However, it can never make the final decision in the matter. We require the final judgment before the situation worsens. Should we be denied direct access to this court, by the time we make our way to the Supreme Court of Appeal and the judgment is not handed in our favor, the appellant won't be able to approach the Constitutional Court because they would be sick and demoralized. Approaching the Supreme Court of Appeal would be a waste of time, resources, and costs. Because the matter is urgent, we require the court to hand down the final judgment. The Constitutional Court, we're also aware that the Constitutional Court makes final decisions. Should we be granted the judgment in the Constitutional Court, as the appellant we know? Yes, Justice?
Are you saying that the Supreme Court of Appeal does not make final judgments? Is that what you're saying?
No, Justice, that's not what we're saying. What we are saying is if we make our way to the Supreme Court of Appeal and we are dissatisfied with the judgment and you also rule in favor of the respondents again, it will be a waste of time and costs. Not only that, but the appellant won't
But
have.
why would you want to preempt the judgment of the Constitution of the Supreme Court of Appeal without knowing what they will find?
The reason we would preempt that decision is simply because when we made our way to the High Court, we believed that we have a strong case because there's infringement of fundamental rights. But not only that, the Shekinah Msingi community have been adversely affected in terms of livelihood. Such rights such as human dignity, which ought to be protected as eternally, have been infringed. But not only that, people are homeless and vulnerable. And if they're homeless and vulnerable, subjected to weather conditions that we don't know of, it also pertains to the infringement of the right to life. And we really don't want people to die as we're still making our way to the Supreme Court of Appeal. So we rather shoot straight to the Constitutional Court, because we know that if you grant us the final straw, as the appellant will be able to deal with the situation, as opposed to making our way to the Supreme Court of Appeal and then coming back to the Constitutional Court if we are dissatisfied with the judgment there.
But Counsel, the Supreme Court of Appeal is there for a reason. And that is why when parties have issues with judgments of first instance, such as the High Court, they have to go to the Supreme Court of Appeal, not to come directly to the Constitutional Court. And I do not really find any tangible arguments from you which says that you have a right to come and appear before us, because you seem to be saying that the Supreme Court of Appeal is useless. That's what I'm getting from your arguments, because you don't want to take your cases there. You just want to come directly to the Constitutional Court. So I am saying to you, the Supreme Court of Appeal is there for a reason. And you can't just jump it for the sake of jumping it and come to the Constitutional Court. Otherwise, you need to convince us why do you jump the Supreme Court of Appeal and come to the Constitutional Court. Please.
And in the event that you will not be happy with this judgment, remember, coming to court doesn't mean that you'll get the relief that you seek. So in the event that you do not get the relief that you desire, what then will be your recourse? You can take your submissions from there, and please proceed.
Okay, I would love to answer the first question from the first justice. So besides the time, besides the reason of time and money, we are also introducing to the panel that we are dealing with people who are left homeless and are subjected to unfavorable weather conditions. So the problem that we're dealing with is if we make our way to the Supreme Court of Appeal and the judgment is not in our favor still, we're still going to have to come to the Constitutional Court. We are not sure if majority of the Shekinah Msingi people, by the time we make our way to the Constitutional Court, they will still be alive. So the thing that we are advocating here for is protect the right to life. Because majority of them, if you're going to be left homeless without shelter, food, and life, which are...
Counsel, what makes you think that the Supreme Court of Appeal will not find in your favor? Because it seems like you have some issues with the Supreme Court of Appeal. You do not want to go there. You are preempting exactly what they are going to find if you take your case there. What is it that you know that we don't know about the Supreme Court of Appeal?
Well, the first time we went to the High Court, we were super confident that the bench were going to rule in our favor because there's an infringement of fundamental rights which I've stipulated.
Perhaps let me assist you. You need to argue and direct us to the issue of the importance of human rights, because constitutional rights talk along those lines, because what you are giving us really is not making sense. Don't preempt what the court will say. Tell us the importance of human rights and why you should come directly to the Constitutional Court. At least that should assist you. Please proceed.
I meant to say constitutional rights, such as the human dignity, such as the right to tradition and culture, such as the right to children being protected with those rights. But not only that, the most importantly one, the human dignity and life. Hence, we are trying to make our Constitutional Court, make our way in this honorable court instead of making our way to the Supreme Court of Appeal. So the reason we're here, we are in fear. Like I said, if the Supreme Court of Appeal doesn't grant the judgment in our favor.
That's exactly what I don't want to hear. don't talk bad about the Supreme Court of Appeal. Try to argue your case and justify it in terms of human rights and their importance in terms of the Constitution, without involving the Supreme Court. Because the Supreme Court, you can take your
Okay, let me just finish.
My learned colleague here has put it to you that you take your cases to the court and you are not guaranteed that you will win or lose. The court will listen to what you are presenting, and then they will make their judgment based on what you are presenting. So it doesn't mean that jumping the Supreme Court of Appeal and coming to the CC, you will win the case. So hence I'm saying to you, try to argue on the issues of constitutional right without dragging the name of the Supreme Court of Appeal that they will not find in your favor, because you did not take your case there.
Section 10 of the Constitution, which is human dignity, has been violated, and we ought to believe it's a non-degradable right that ought to be protected eternally. Secondly, Section 30 and Section 31 of the Constitution, which is the right to use of language, religion, and culture, has been violated. The people at the Shiklenim Single community won't be able to make use of proximity of close rivers and ravines, because now they will have to be relocated to the city center. And when we make our way to the city center, there's lack of rivers and ravines there, and they need the spiritual element of water to connect with their ancestors. Another right will be Section 29, subsection 1, which is the right to education. When the children were being moved from the Shiklenim Single community to make their way to city center, the right to education was not taken into account, and the paramount interest was also not taken into account, because if they make their way to the city center, for you to be enrolled in a new school, we have to follow administrative process and enrollment at that. But currently, even now, because they're not being taken to the city center, they were just forcefully removed. They're not able to acquire that education because they've been left in the streets homeless to fend for themselves. But also another right to basic shelter, food, and water has also been violated, because when they're left homeless at the streets, they don't have food and water, which are basic essentials to survive. And secondly, going to the question that the second justice have asked, that we are not of guarantee that when we make our way to the Constitutional Court, they will rule in our favor. And if they don't rule in our favor at the Constitutional Court, it is then when we will seek for alternative dispute resolutions, such as mediation and arbitration. And
That should be the first thing you do before you go to the Constitutional Court, or before you can even go to any court. You are advised to seek other forms of
remedies.
So you don't start with the Constitutional Court. You start with those and then you go to the Constitutional Court. So keep that in mind in the future when you ask. Thank you.
Counsel, I want you to indulge this court, and perhaps I'm trying to assist you. If you look at the facts of the matter in question at 2.12, it says there, and I'll read it verbatim, that the relocation settlement contains the following information. Amongst other things, A, the community should be relocated to the nearest city center. B, that the graves in the cemeteries will have to be exhumed and relocated to the nearest city center graveyard or alternative graveyard. So, as my co-justice has asked you, I want you to indulge this court. What agency is there? Because seems to the court that remedies are already in place, that these people should be relocated. So what is the agency that is here so much that the SCA could not indulge you on this matter? And secondly, what public interest is there? Because it appears to us that the only interest is those of the Shiklenim Mkenge community. What public interest does it serve?
Thank you, Justice. Answering the first question, we are not disputing that the SSCA is not a competent court. That's not what we're saying. But we are just saying that when they're relocated to a city center, there are certain rights and traditions that would make it impossible for them to practice there. And not only that, in terms of being relocated to the city center, there are people who live in the community like Gokom Tembu who are being traditional healers. And if they make their way to a place like a city center, in most city centers, they don't have like a plethora of plants. They don't have a lot of biodiversity that will make Gokom Tembu be able to practice his own traditional culture. And I think this is the reason why the Shikeli Msingu also don't want to move there. It's because of the fertile soil that also allows them to plant different types of plants that gives them access to food. And with the exhuming of cemeteries, the respondents haven't made like an exhumation consultation with the rightful people in this matter. You have to go to the beloved people of the family and tell them that I would be exhuming your beloved ones here. But not only that, you still need a police officer at hand. There are different departments that you have to engage with, different Department of Health, and you also have to engage with the Department of Eastern Cape. It's not something that will just happen in a 1-minute situation.
Just one last one, Council, from my side. Is your submission to this court that traditional healers or leaders in the city centers cannot practice because they are in the city?
We are not saying they won't be able to practice because they're in the city. We're just saying that they don't have various plans in the cities that will be able to accommodate to their practices, because they also need specific types when they're practicing traditional medicine to make that kind of traditional medicine to heal people. Not every different type of plant is found in the city center. And in most cases, if you look at the city center, already things have been accommodated. It's a lot of buildings, it's churches, it's already a lot of accommodation. There's not a lot of biodiversity, there's not a lot of land for them to be able to find those various plants and biodiversity, various plants.
You may proceed, Council.
The Constitutional Court makes final decisions, meaning it is the last straw for the applicant. In Democratic vs. Minister of Home Affairs, their matter was considered to be urgent and they were granted direct access because of their exceptional circumstances. We plead with this honorable court for the same thing to be done with us and have a favorable judgment. If the justices don't have any further questions, I would love to proceed to my next issue, which is Lucas Dandi. The applicant has a standing to approach the court. Section 38 of the Constitution states that if a right is threatened, you might make your way to the court to be able to protect it. The applicant further acted in their capacity in terms of Section 38, subsection A. Anyone acting as a member or interest or
Ms.
group
Mola,
of people.
if I can just interrupt you there, in the interest of time. I mean, there is 10 minutes left for your team. You've already taken up 20.
Okay.
I think you will have to hand over to your colleague to proceed with the next point. Thank you. It's Ms. Litswalo, right? Yes. Please proceed, Ms. Litswalo, and leave enough time for your colleague as well.
Okay. Good day, Justices of this Honourable Court. I believe my co-counsel has demonstrated the constitutionality of the removal and resettlement of the communities taking to Section 25 of the Constitution. I'll further demonstrate and highlight, because we don't have time, Justices. Justices, I also want to raise something that you raised, that they're saying that city center, they can't practice their cultural and traditional practices. I'd like to add on what she said, that the respondents did not consider the current use of property and the use of property. The Shikeli community members, they rely on informal economy, and they use the very same land for their traditional and cultural practices. For instance, Rosalind Diko and Temba Malulegi, the first and second applicants, are are using the very same land for vegetation farming. They cannot farm on city centers because city centers it's dominated with buildings, and there's only certain plots of land that are fertile, and those lands, those plots of lands, they are expensive. Of course, they wouldn't even have money to buy those plots. And again, furthermore, justices, is the fact that they rely on informal economy, and they rely on selling vegetables, selling their poultry, and making and selling their livestock. There is no way livestock is going to be placed in a hole like this. The respondents did not consider the current use of property and the use of property in terms of Section 25, subsection 3 A and B of the Constitution, to add on what my co-counsel said. May I further just continue to the next issue?
Yeah, with very limited time, but if you can summarize it. Remember, you, as the applicants, you still come back to replicate,
yes.
And maybe you can sum up everything in replication. But we have had sight of your heads of argument. So
Yes.
Perhaps your colleague may proceed on a final point, and then the rest perhaps can be sorted out in replication.
Okay, correct.
In the interest of time, how much time do we have? 7 minutes. You can take 2 minutes and 5 for your colleague. Thank you.
Okay, justices of this honorable court, I also want to make a point on the Save the Culture, the and the NGO, that they have evidence on how the Shikini community members were evicted in the matter. This illustrates how they did not respect and protect their dignity, because this illustrates that the scene was so dramatic and severe to a point where they recorded the whole altercation. It also illustrates that the IMC is dishonest when it claims or alleges that they did indeed respect the right to dignity and the right and the rights of the traditional and cultural practices. And justices, we need to take note of the fact that the right to dignity is equated to the right of life, and this was also highlighted in the case of State versus Makwaning in the Constitutional Court. If it pleases the honorable court, may I cede the podium to my co-counsel?
Maybe just before you do, is it your submission that the mine would not be to the benefit of the community for a formal economy?
Good question, Justice. Justice, it would be for the benefit of the economy. However, the relocation settlements agreement does not include the community's needs at all. It in fact places Mr. Nkobodi in a superior position. So Mr. Nkobodi wanted sustainable development for himself and not the community at large. Therefore, Mr. Nkobodi is the one who's going to be benefiting from this whole outcome and not the community at large, because the community is the one who's going to be suffering in the matter instead of the community.
But Mr. Nkobodi only wants to be the director of the school. How is he going to stand to benefit from the mine?
The mine, the IMC promised that they're going to build a school a blind school to the Shikini community, and he's going to be the director of the school. So justices, obviously, being the director of the school, he's going to be remunerated for that, and he alone will benefit alone, and not the community at large. And not every child is blind, justices. Not every child is blind in the community. They should have considered the issues that are of great concern in the community, which is the fact that they rely on informal economy. If it pleases the court, may I?
Thank you, Ms. Litswalo. Over to Ms. Jaji.
As a court, please, Justice.
Good morning, my justices. I'll be making submissions on the children's rights, the protection of the children's rights, and the civic culture as an amicus curiae, and the submission of the prayers. I'd like to submit that Section 28, subsection 2 was violated in this matter in terms of the children being of paramount importance in this matter, the children's interest being of paramount importance in this matter. I would like to submit that the state, including the president and all other relevant ministers, have failed to protect and promote the rights of children in this matter. If it pleases the court, may I proceed to my next submission?
Proceed.
I therefore submit that Save the Culture being admitted as an amicus will actually have an impact, a positive impact in this case, as they have tangible evidence, audios, recordings that portray how cruel the people were removed from the Shitlini Msenge community. Therefore, I submit and request to this honorable court that Save the Culture be admitted as an amicus curiae in terms of Rule 10, Sub-Rule 4 of the Constitutional Court rules. If it pleases the court, may I proceed to my next submission, which is the prayers.
Before you proceed with the prayers, on the court's discretion to admit the amicus, I feel you're not making out a case. The fact that they've got evidence to give the court, that evidence could be provided by way of an affidavit and not by necessarily bringing them in as a party to your proceedings. Those recordings, I'm sure the rules of evidence do make provision for the submission of such evidence without admitting them as amicus. Is that not so?
It is so, my lordship. My justices. In terms, I'll quote a journal, break the silence, friends of the court. It was stated that the courts in South Africa, the South African courts, are increasingly recognizing a perspective and a voice of a different entity that does not have an interest in the matter at hand. I believe putting them in a stand to present their evidence or their expertise with regard to...
Ms. Judge, finally, I'm listening to your passage, and I feel it's very relevant to what I'm asking. Your colleagues have stood here and painted a picture of extreme urgency. And in an urgent situation like this, you still want to go in and invite friends.
I believe when they did not get the verdict in their favor in the first court of instance, which is the High Court, they had to bring something new that would support their argument in this matter.
Was the High Court application an urgent application?
I believe it was.
Thank you, Ms. Judge.
If it pleases you, Justices, may I proceed to the prayers?
Please proceed.
We pray that this honorable court rule in the favor of the applicants in this matter. One, grant the appellants direct access to this honorable court. Number two, the court to issue spoliation order reinstating the appellants back to their honorable land, the ancestral land that they've lived in for over 200 years.
Ms. Judge, just to interrupt you in the interest of time, are your prayers as indicated in the heads of argument?
Yes.
They are duly noted. Thank you very much.
If it pleases the court, may I rest my...
Thank you, Ms. Judge. For the respondents.
As it pleases the court, the applicants seek leave to this court, and if granted, in
Ma'am,
order.
Can you just, for the record,
My name again?
Your initials and surname?
Okay. As the court pleases, L.O. Sihule.
Please proceed.
Okay. The applicants seek leave to appeal to this court, and if granted, an order setting aside an order granted by the court ACOR. In their heads of argument, the applicants immediately capture their attention referring to the alleged community, hereafter as the fifth applicants, who are the fifth applicants who became the owners of the land in the Bokan region in the Eastern Cape for more than 200 years, and who continuously and without interruption were farming and sold vegetables and pottery for a living in a mining, but the mining company, which is the Iron Mining Rights, the Iron African Mining Company, actually got the rights to mine in their land. Our arguments.
What issues are you dealing with?
I'm actually going to be structuring out how our argument's going to follow, and then my co-counsel will take it from there.
But logic.
I was giving out the facts of how the facts of the case on why the coming here to court would be a waste. So I actually wanted to open up by giving an opening statement first, and then setting aside on how proceedings will continue from there.
Okay, proceed.
Okay.
But now, in the interest of time, remember you only have one bite on the cherry, and in the interest of time, will this preamble really benefit the rest of the legal team, or should it be perhaps as brief as possible?
I think we'll be able to cover on time.
Thank you. Please proceed, ma'am.
All right. Our arguments are structured as follows. The nature of the applicant's rights to the fifth applicants, the alleged invalidity of the mining right and the relocation settlement, the argument that the mining respondents are not entitled to the mine despite the mining right in terms of the Mineral and Petroleum Resources Development Act, and in terms of Section 6 of the interim arrangement and relocation, and the arguments based on the issues of fact. That will be the last. If the court allows me, I now call my co-counsel, Karabo Pilani, to deal on the issues of jurisdiction, direct access, and urgency, and Amicus curiae. Thank you.
Thank you. Please proceed, counsel.
As the court pleases, my name is K.N. Pilani. I will be dealing with the issue of direct access. The respondents submit that it is not necessary that this matter be addressed directly to this court. The Constitution entrusts the Supreme Court of Appeal under Section 168, subsection 3, paragraph B, that it may decide appeals in any matter arising from the High Court of South Africa or a court of a similar status, except only in matters of labor or competition. The issue raised by the applicant about the agency of this matter is vague and embarrassing, as the seventh respondent has offered an alternative accommodation near the city center, and the relocation settlement has already been signed and by Mr. Ngopodi on behalf of the community. Therefore, the respondent has complied with the requirements as contained in the settlement agreement. And further to that, they has also complied with the requirements of the MPRDA as contained in Section 5, subsection 4. Counsel, I am tempted to interrupt you. When we go to the set of facts, paragraph 2.8, It is very clear there that just one member of the community took it upon himself to go there and conclude a deal on behalf of the community, but you come here and tell us this matter is embarrassing. The community was consulted, but clearly the facts are not saying that. Can you please respond to 2.8 of the set of facts and not mislead the court by telling us that the community was part of this agreement when it's clear there that only one person concluded this deal on behalf of the community? As the court pleases, if the court can turn to paragraph 2.11 of the facts. It is stated that the consultation process have been ongoing. It is only at the later stage that when the leader of the ACC was ill, is then that Mr. Nkopodi came. So, and then Mr. Nkopodi came representing the applicants in this matter. And then he is the member of the ACC, which is the seventh respondent, the seventh applicant in this case. Therefore, Mr. Nkopodi was acting on behalf of the community. What do you say about 2.8? Because that's where I directed you to. And you need to respond to that. In relation to 2.8, as the court pleases, the consultations have been going on. The respondents, the mining company, has complied with Section 5.4. Where do you get that in the set of facts that the community was consulted? Where do you get that? Please direct the court to the relevant section, because I am directing you to to paragraph 2.8 of the set of facts. You can proceed to make your presentation.
Yep.
As the court pleases, I will come to directly point out which paragraph I'm referring to.
But counsel, also to add on what my colleague has asked you on paragraph 2.5 of the facts, you would see that there ought to be 4 members of the ACC concurring with the decision. And Mr. Nkopodi still went on to get into the agreement on his own. Are you saying that it's still embarrassing even though the 4 other members of the ACC were not there?
No, what I'm contending, your justices, is that Mr. Nkopodi did act under the consent of the community, or he got the mandate from the community, because pursuant to so, counsel, I'm going to interrupt you again. If you say that Mr. Nkopodi got the consent of the community, now the very same community is refusing to move, and they are forcefully moved. But you are saying that Mr. Nkopodi got the permission of the community to go and conclude the deal on behalf of the community. Are you saying to us that this community is perhaps not compos mentis? The community is not saying that in line with the agreement that has been done by the ACC, because Mr. Nkopodi is a member of the ACC. So if Mr. Nkopodi gave the consent, he was doing so upon his position as standing for the leader of the ACC. But my learned colleague here just reminded you of 4 council members who must all agree
and conclude an agreement on behalf of the community. These other three were not part of this.
As the court places, the respondents has not been given the constitution of the ACC, so they cannot be expected to know what is it that the consultation process.
Isn't it the duty of you as counsel for the respondents to do research, get your facts right, so that when you come to this court, instead of saying the community is embarrassing themselves, perhaps you will be embarrassing yourselves by not doing proper research? You may continue, counsel.
As the court pleases, I now deal with the matter of agency. The applicant is not agent, no basis for agency of the relief sought. We respectively submit that an application that is stillborn for all the reasons we will advance can never be agent. We submit that the application should be dismissed for lack of agency for the following additional reasons. Agent application in this court are governed by Rule 12, which is similar to Rule 612 of the Uniform Rules of the Court. The latter provides that parties seeking relief must explain and justify asserted agency. This court in particular will hear a matter on the basis of agency only in exceptional circumstances. It has been repeatedly observed that this court is not well suited to hear agent matters, and it must benefit from the Supreme Court of Appeal when the matter has been appealed.
What is your authority for that?
My authority for that is section 168 of the Constitution that entrusts.
Please read it for the court.
The Supreme Court of Appeal, subsection 2, a matter before the Supreme Court of Appeal must be decided by a number of judges determined in terms of the Act of Parliament.
So, counsel, you see that you are misleading the court.
Let me proceed to subsection 3. The Supreme Court of Appeal may decide appeals in any matter arising from the High Court of South Africa or a court of a status similar to the High Court.
But
and then,
counsel, you were addressing the court on the issue, trying to prove that this matter is not urgent, and it should not be it should not have been brought before this court. And I ask you, what is your authority for that? Now you refer to some sections which talks about the Supreme Court of Appeal, not this court.
And perhaps just to assist you there, which rule, can you refer us to the rule, and what are the requirements for agency where the rule is concerned? And in light of those requirements for agency, why do you then say this matter is not urgent?
As the court pleases, Rule 19 of the Constitutional Court contains the procedure for direct appeals to the Constitutional Court. Rule 19 of the Constitutional Court rules.
What does it say?
It says, a litigant who is aggrieved by the decision of a court and who wishes to appeal against it directly to the court on a constitutional matter shall, within the specified time of the order against which the appeal is sought, to be brought, and after giving notice to the other party or parties concerned, lodge with the registrar an application for leave to appeal, provided that where the president has refused leave to appeal, the period prescribed in this rule shall run from the date of the order refusing leave.
Is that relevant to the question? It's not. So
the court wanted to know under which rule can a person bring a direct appeal to the court.
Exactly. And you are against that. Is there anything is there anything wrong that was done in terms of that rule, in terms of the very same rule that you've just read before us? Is there anything wrong that was done by the appellants for bringing their matter here?
What I'm arguing, Justice, is the matter of agency. If they say the matter is agent, when they were offered an alternative accommodation, how can it be that the matter can be agent and want to be admitted or heard in this court when they have in fact didn't want to actually relocate to the place that was offered, which is the city center?
But Council, do you not think that it's urgent solely on the basis that where they lived before, they were able to make means through vegetation? What are they eating at the moment? Is it not urgent that the people are hungry?
As the court pleases, the MPRDA under section 100 subsection 2, it does give the minister a power to enact the rules that will make the development, that will provide for the development of the communities. So the Manning Charter in that regard, it has been done in order to make sure that the community that lives around the mining industries, they are being developed. So in terms of the Mining Charter, if the community had a dispute for the mine to continue, they had to exercise their right in terms of Section 54.
Council, I don't think you're answering. I actually would then direct it to a yes or no. Are you telling this court that it's not urgent that the community people are hungry?
Yes, but on that one, however, the community has been offered an alternative decision, an alternative accommodation. So it cannot be agent where an accommodation is there, and then the relocation settlement has been signed.
Council, we're dealing with human beings, and I asked you, and I want us to move on, save for time. You and I agree that it's urgent that the people are hungry.
As the court pleases.
You may proceed, Council.
I now continue to deal with the admission of Amicus curiae, of Save the Culture to be admitted as Amicus curiae. Respondents dispute admission of Save the Culture to be admitted as an Amicus curiae. Constitutional court rules provide that a person may be admitted as an amicus curiae either on the basis of the written consent of all the parties in the proceedings. That is contained in Rule 10. Or on the basis of an application addressed to the Chief Justice. It is submitted that the written consent from the respondents has not been secured by the applicants. Therefore, the respondents could have invoked Rule 10 sub-Rule 4 of the Constitutional Court Rules to apply to write a letter to the Chief Justice for a Chief Justice to make a discretion as to whether
you say
or
the
not.
Respondent. Did I hear you correct?
I beg your pardon? As the court pleases.
I heard you saying the respondents could have.
The applicants, I'm sorry, Justice. The applicants.
I think we need to clarify this issue and differentiate between the two. The applicants and the amicus, because these are not the same.
Yes.
So the amicus normally will join the court as friends of the court. They are not the friends of the applicants. They are the friends of the court. So when you do your presentation, do not say the applicants should have, because they can't go to the court and say, we want to bring amicus. Amicus must come on its own to say that we have interest in the matter. That's how it goes. You may proceed.
As the court pleases, the amicus curiae. The amicus curiae wanted to be admitted to advance the information or the case for the applicants.
I just said to you, they cannot appear to advance a case of any of the parties. They must go there to assist the court to come into a correct decision, not to favor the applicants or to favor the respondents. They assist the court, not the parties.
As the court pleases, can I point the court to paragraph 2.14 of the facts, which says it is line number 2. Okay, actually, let me start from line 1. It says, an NGO by the name of Save the Culture, which is unregistered in South Africa, but has advised the court in all other countries, seek to support the applicants in the matter. It is clear from the facts.
Yes, it is your duty to research and get the law correctly. The role of the amicus is to assist the court.
As the court pleases, hence we say it must be dismissed, because clearly from the facts, what they are coming is to advance the cause or the matter of the applicant. It is clear from the facts, as I've read the facts.
Okay.
The purpose of amicus is to further bring to the attention of the court matters of law and fact to which attention would not otherwise have been drawn. The amicus bore a special duty to the court in return for the privilege of participating in the proceedings without having to qualify as a party. That duty to provide cogent and helpful admission that assists the court. The amicus must not repeat arguments already made, but must raise new contentions, and in general, these new contentions must be raised on the data already before the court. The conveners of the Safe Culture believe that their intimate knowledge of the issues that have led to the conflict, coupled with their vast collection of evidence, would be of assistance to the court. It is submitted that such evidence would not constitute would constitute a substantial body of new evidence in a form of the documentary, audio, and the video recording. And therefore, we make submissions that it will be a waste of cost, time, and the resources, because a court will have to go through that evidentiary material, and which will not even assist the court. As the court pleases, if I'm of no further use to the court, I now invite my co-counsel to deal with other matters.
Thank you, Counsel.
As the court pleases, your justices, I'll answer the question that was given to my co-counsel regarding the consultation with the community. The requirement of consultation with owners and occupiers.
Ma'am.
Oh, RS Moekwa. Initials. The requirement of consultation with owners and occupiers after the grant of a mining right is not the exercise of a public power by the 7th respondents, but to determine the extent of the conferred limited right, but is a mechanism to attain a civil exercise of the limited right. I'm going to deal with the issue of Section 25 of the Constitution.
Counsel, are you representing the President, the Minister? Who are you representing?
The respondents.
All of them?
Yes. Okay. As the court pleases, your justices, we submit that the appellant has erred that the removal from the Shiklenim Senge community violated Section 25, subsection 2 of the Constitution, because property may be expropriated only if it's for the purpose or the interest of the public. The mining operations, as stated in paragraph 1 of the facts, contributes a lot of...
Can you please read for the court Section 26, subsection 3 of the Constitution?
Section 26?
Yes.
Section 26 is about the right to housing.
Subsection 3, yes. Please read it for the court. Do you have a copy of the Constitution with you?
As the court pleases your justices, Section 26, subsection 3 states that no one may be evicted from their home or have their home demolished without an order of the court made after considering all the relevant circumstances. No legislation may permit arbitrary evictions.
Thank you so much. According to the set of facts, we are told that there have been forced removals. I see you are representing the respondents, all of them. So the question is, did your client get a court order to evict these people?
As the court pleases...
If no, is that not a violation of Section 26, subsection 3 of the Constitution?
According to the facts of the case, the 7th respondents were granted the mining rights. The minister and the president...
The question, Counsel. The question is, Section 26, subsection 3 says that you cannot evict anyone without a court order. And now the question is, did your clients obtain a court order to evict or forcefully remove these members of the community?
As the court pleases, before evicting or removing the Shiklenim Senge community, Mr. Nkopodi gave consent unilaterally that the community will be moved to the city center. So according to Section 6 of the Interim Protection Act of Informal Land Rights, the alternative accommodation was given to the applicants.
If you refer us to that interim, what is interim what?
Protection.
Protection. I will refer you to Section 2 again of the Constitution, which says that document that you have in your hand is the supreme law. Any law or conduct which is against the provision of that document that you have in your hand.
As the court pleases.
I want you to assist this court so that we save time. Do you have a copy of the court order that allowed the evictions?
As the court pleases your justices, no.
So you are submitting to the court that the removals were illegal?
As the court pleases your justices, according to Section 2A, 2 subsection, according to objects of the MPRDA, internationally it's accepted of the state to exercise sovereignty over the mineral and petroleum resources. And Section 12, subsection 1 of the MPRDA states that the mining operations will assist historically the disadvantaged people.
Counsel, I think you are evading the question. There is no court order granting the evictions. So now are you inviting this court to rule on something that is illegal?
As the court pleases your justices, in the instructions it is stated that in the lower court, which is the high court, it was in favor of the respondents to continue mining since the legislative requirements were met.
And that's why we're here today. The appellants are here to tell us that that court had in granting that.
Is there any legislation that contradicts what my brother has led you to in section 26 that perhaps indicates that such action is permissible without a court order. Is there such?
In section 10, subsection 2, it states that a person objecting the granting of a mining right must refer to Regional Mining Development and Environmental Committee. For over 9 years, the mining operations were not proceeding.
It's not what I'm asking. My brother asked you to read the
section 26.
Section 26, and it's quite explicit. I'm saying, is there any other authority that supersedes that legal provision?
No, Your Justices.
Thank you.
According to section 10, subsection 2 of the MPRDA, it states that a person objecting the right must write to the Regional Mining Development. However, the fifth applicant had the whole 9 years to object, but decided to move and settle into the Shikuni community. Section 18, subsection 1 of the MPRDA states that the seventh respondent can also approach or apply for the renewal of the prospecting. If any holder of a prospecting right who wishes to apply for the prospecting right must apply at an office of a regional manager. Issue 4 regarding the right to human dignity and religious. The minister and the president, including the Minister of Human Settlement, hereinafter the seventh respondents, the first, the second, and the third respondent had no objection regarding the opposed development, despite the fact that it was noted that the development would have negative impact on the land, which is going to affect the farming, the grazing of the cattle, the nutrients of the soil. When the minister grants the mining right accordingly, it diminishes the surface of the rights of the owner and informal land rights of the respondent.
Ms. Moegwa, your time is up.
As the court pleases, Your Justice.
Perhaps can we just then have 2 minutes, just a minute to wrap up, and I still think we still need to hear a little bit from your colleague. Just a minute to wrap up, and your colleague will take over.
As the court pleases, Your Justice.
Sure.
As the court pleases, I don't have to say my names again, right?
It's okay, ma'am. Please proceed.
Okay. As the court pleases, I'll be dealing with the issue of the constitutional rights of the Eastern Cape in regard with the provisions of alternative housing. The Constitution of the government under Section 26, subsection 2, states that the legislative must be taken into measures within its reasonable resources to achieve the progressive realization of this right. So we submit as the respondents that the government have met their obligation in the second and third respondent as custodian to the management of country's mineral resources, have developed a regulatory framework under the Section 100, subsection 2 of the MPRDA in the form of the mining charter. With this being said, it must be placed on record that the removals were affected before the court order to be ruled in favor of the respondents, with Section 26, Issue 3, after considering the fact that the relevant circumstances and it submitted that the eviction was not done arbitrarily. When I get to the case of the children in this instance, it won't be only the community benefiting from the mining operations in the land, but also the children, because when the community is moved to the city center, they will be able to access developed schools and develop a much more developed area. And it's not like we wouldn't have water. There will be still water for them to practice their cultural needs and
Please
yes.
allow me to interrupt you.
Okay.
We are Africans. And these people, these communities are viewing that their graves lies there. There's rivers, there's dams, where this community perform certain rituals. In terms of African customary law, some people, when they are born, they will take the umbilical cord, go to some river or a dam around the community and perform a ritual there and throw that umbilical cord there. And they say that that child, when they grow, they will be connecting with the ancestors, so on and so forth. That's the practice of Africans. And now if you come and destroy these streams, dams, and rivers, and you transfer these people to another place, yes, there will be rivers and dams, but they will not be the same. So those people will not be able to connect with their ancestors. Don't you think that is a violation of the Constitution, the Bill of Rights? Because the Bill of Rights says that you must respect cultural practices. And you come here, you tell us that yes, these people will go there, they will get other dams and other waters and rivers, but they are arguing that they have connection to this community with the land, the rivers, and everything of that community. Don't you think that if you move them, you will be violating their rights?
As the court pleases your justice.
How will you justify moving these people when they are arguing all these things in terms of customary law?
When you put that as a fact, like the way you put it, yes, it is in violation. But when we had a meeting or consultation with them, as we're in the process of those processes, we were in the agreement process. They were explained, and such things we also, as the mining company, thought of such. And instead, we were actually bringing up a plan, an environmental plan on how they would like to be assisted and so on. But in the meantime, we were more focused on them not being on the streets, because we were thinking of their lives as well, that they won't have to be on the streets if we give them the alternative housing. But in as much as the process of agreements were being made, we couldn't reach that agreement, or they didn't come back to us to let us know in a sense whereby they were organized. Because when I get back to the facts, Mr. Nkopodi, as he acted unilaterally, we believe that it is not our responsibility to actually get them organized as the leaders. So because they decided to do, Mr. Nkopodi decided to do that unilaterally without our knowledge also, we figured that we were gonna give them the environmental plan on that would actually have the requirements they needed. But because of the things that Mr. Nkopodi proposed to us, those were the things that we offered them, which was the building of the school and making Mr. Nkopodi the director.
Council, as you wrap up, are you saying the environmental plan would be to recreate the forest that was at the community? Are you going to take the forest that was there to the city center, the streams?
Not necessarily, and it does not mean that the city doesn't have rivers and so on. The city also does have, but we would have at least come up with a mandate that if they wanted to practice their cultures and so, they would have also had such rights in that particular city. Because as, I don't know, in other cities they don't allow certain cultures to be done, or let's say when we talk of the townhouses and so on, they don't allow such, or there's no such. But when we, as the mining, when they propose such, we can actually go back to our agreement and then make means that they get such rights to be practiced with whatever they get there as resources to help them out.
Council, as you close, as your closing argument, I think you want to agree that you're going to be violating the cultural rights of the community. I invite you to indulge this court and tell us why should we grant you the order to proceed with the contract if they won't be able to practice their culture in the city center. You have said yourself, and you have made a submission to this court, like in other areas they do not allow certain cultures to be practiced. What in your mind do you think will be happening if the Nyanga wants to practice his rituals at night in a townhouse? What's going to happen?
Okay, as the court pleases. Your justices, the city center is not a townhouse place, like we say. It's a normal city, but because we were in the middle of the proceedings, like we said, we were supposed to receive a mandate of the things that they actually needed from us. But because their mandate didn't accommodate such, it is not our intention to actually neglect their cultural rights. But they were more focused when they gave us their request of probably compensation or so. They decided they only need the blind school and a particular person being the director of that school.
It was not them, it was him. It was one person. Are you agreeing with the court?
Yes, it was him on behalf of them.
Where in the facts does it state that it was on behalf of the community?
Let me quickly.
Besides, the fact is that the community now is disputed. Is coming before the court to say that we are being forcefully removed, which proves that that person made that decision on his behalf, not on behalf of the community.
Yes, Your Justices, if the court allows me, I was saying that from the respondents, we were not obliged to actually make the ACC organized.
But
prior to that...
Counsel, can I ask you, seeing that now the community is having issue with you coming in to remove them, why didn't you perhaps go back and listen to them why they are refusing to move, even though you know that your clients have entered into an agreement with one Mr. Nkopoti? Perhaps you should have gone back to the community and listened to them. Why is all of a sudden you are saying that you are no longer, you don't want to move, when we have a contract which was signed on your behalf that you are agreeing that you will move, we'll build you a school, we'll make one of your own a director? Why didn't you do that? That's one. Number two, I am not hearing you pursuing the point of this company coming in to change the lives of this community because the facts are saying that they were relying on informal agriculture. So this company clearly should be bringing a lot of development. People will be getting jobs. There will be development. They might build hospitals. They can build schools, roads, infrastructure, sports, recreation. So I was expecting to hear you guys saying all those things, but you are not saying that. You keep on,
Okay. On that issue, as the court pleases, we have met, as the respondents, we have mentioned before, that we have met all the requirements, meaning as the mining company, we obviously saying we didn't want to give a plan on how they are going to go to school and so on. We are actually saying when they move to that school, and when they move to the city center, then that's when they will be developed, because that city center is also developed compared to where they've been staying right now. So we are taking into consideration on how the sports recreation and how their livelihood would be. And the plan was to also give them those jobs and create those jobs as we'll be mining in that particular land. So at least they'll be able to maintain themselves in taking the kids to school and then also maintaining the livelihood of the daily lives. But in terms of the cultural rights they have, like we've said, we actually expected them to let us know, because we as the mining company, we were expecting them that they must tell us the requirements they need in order for that city center to actually accommodate to their cultural rights as well.
Counsel, the law which governs the exhumation of graves and moving them from one place to another,
it's the Health Act.
What does it say? Doesn't it say that when you want to do that, the family or the relatives of the people who are sleeping in those graves must be consulted, and they should consent to that? And now the community is saying, no, we don't want to move. How are you going to deal with the issue of relocating the graves without the consent of these people? Because it's the law is there, it says that you must consult the owners of the graves for you to be able to move the graves.
Your Justice, if I may say, I still emphasize on the fact that we have met all the requirements, meaning we have also went through the Health Act, as is that law that covers the exhumission of those graveyards. So in that manner, I believe that as the respondents, we were considering such facts, and we were able to cover that as we're going to be moving the graveyards to the city center. We took the initiative from the person who said, or who came to us in respect of the community, who gave us the right of way to continue and move them to relocate them to another settlement. Then that's how we acted off in such a manner that we must take these people out, because we got the consent from a person who was actually representing them, as it was said, because he said to us that finally you came to in the facts in paragraph 29, he did mention that we have come to the right people for consultation, because standing before you is the voice of authority. So prior to our meetings and consultations with them, Mr. Nkopodi was part of that. So we believed, and it was easy for us to believe him when he came to us and said, this particular leader is not well, and I'm here to represent the community.
Counsel, is it not a duty placed upon legal practitioners that when you take upon a mandate, you do thorough research in terms of how certain contracts should be entered into? And if such was exercised, why then should this court now indulge you on a contract that is in fact invalid based on what the constitution of the ACC entails?
As the court pleases, as my co-counsel have mentioned before, during the consultations, we were not finished with such legislative for the community. So.
But now that you're aware, what's your stance on that? Sure.
Our stance is that the court actually should just grant us the mining rights, and we will go back to the drawing board with the community and try to meet their requests.
So we must ignore what is wrong and just grant the wrong right order?
No, because we got an order before, I'm saying that because there was a case that we won the previous case, and the case was in favor of the respondents, we shouldn't also avoid the fact that we went through the proper processes and requirements for us to actually gain the mining right in that land.
Okay, thank you.
Thank you, Counsel. We've heard you. Rebuttals by the applicants. In the interest of time, is there one of you from your legal team who will be dealing with that? Yeah, and then, in just a few minutes, please proceed. It is Ms. Judge, not so?
Yes, Ms. Judge.
All right.
Good day, my justices. If it pleases the court, may I submit my rebuttals in this matter. It was said by our learned colleagues that the matter was embarrassing. The matter brought before the law was embarrassing. I believe there's nothing embarrassing where rights of the community and people are homeless. When people's lives are in danger and they are actually faced with the harsh weather conditions, without shelter, not knowing what you are to eat next or if you're gonna have clean water. In terms of agency, I believe and I consider that people being homeless, it's a matter of agency. There is no way that a person can be out there and then the matter does not raise any point of agency. It further goes that Mr. Nkopodi acted on his own behalf or personal gains, and it was in the interest of his own personal interest, and it was the duty of the respondents to make research to know that a binding contract have to be signed by witnesses in that matter. I also like to submit that Section 26, subsection 3 of the Constitution has been violated by the by the respondent, by not serving eviction or an eviction notice to the people of Chitkinyimsange. And I strongly believe that the MPRD Act does not permit for your violation or how you violated the people within the Chitkinyimsange's community. The administration in terms of education for the children of Chitkinyimsange was violated, because if we believe that standardized education will be provided to the children of Chitkinyimsange in the city center, it should have been done in a correct manner to grant the parents or guardians of the children to find a better school, because not all schools grant better education.
Council, are you submitting to this court that the schools in that particular community are not up to par?
I'm not saying they are not up to par. Not all schools produce the same results. I believe if you have enough time to research, there's a school that produces a 99% matric grade, and there's a school that performs poor every year.
But Council, we are talking about a specific community. They've been moved to the city center. Are you saying in that particular community, they won't be able to be developed properly as opposed to the city center?
If it pleases the court, my justice, would you please repeat the question?
Maybe let me phrase it this way. These children go to school in that particular community. They've been removed and taken to the city center. Are you saying in the schools that are in that particular community, the education is maybe poorer than that one of the city center? Is that your submission?
My submission is, if the kids are comfortable and the SGB of the schools within that community are doing their work in terms of teachers, they can produce better results, and the school will be of higher standard, better than the schools which are in the city center. If it pleases the court, may I, that marks the conclusion of my rebuttals. May I rest.
Thank you. We have had submissions by both teams, and judgment is hereby reserved. Court will now adjourn. All rise. Thanks very much. I think, can we just sit for a second? Just to appreciate both teams. My colleague and I were just gossiping now. It's okay, fine. Let's say something and give an overall remark for a while. And being in court, the main thing that you're always taught as a rule of thumb is the ability to think on your feet, is the ability to master your matter, and don't ever fall into the trap of losing your step when you're speaking or when you're addressing the court. Sometimes you've come so prepared that what you did in front of the mirror is no longer the same as you need to do now. So, number one is to always know your facts. Number two is to know the law and be confident about it, because especially in a setup like this where you are being switched around as an applicant or a respondent. So you need to show confidence on both positions, and also legal confidence on your law and on your arguments. My brother, Mr. Makama, went to great lengths in squeezing that out, in this regard, especially on the side of the respondents. And it was quite impressive to see how they were standing their ground. So a judge will always interrupt you even 5 minutes into your argument, and you might not always get the full benefit of painting your entire picture before you get an interruption. So on matters such as this is a constitutional matter. It borders a lot around the Constitution. And in understanding that the Constitution is the Supreme Court of the land, and it's very clear that any other legislation that contradicts the Constitution becomes illegal. But is that the end of it? Does it mean that there are other legislations that actually, not to say override the Constitution, but perhaps there are certain limitations, there are certain exceptions? What are those? Explore them and make an argument. So is it a wrong thing that now this community will be taken to the city? What can be done to make sure that these rights that they are crying that are being violated, this move can be synonymous with their protection? Now, also, when we go back to our communities and we have this community engagements, do we completely, because there's this issue of urbanization, and what happens to the river? Are you going to take the rivers there with these people? What's going to happen? Are you going to arrange a bus maybe every Friday or every weekend that will take them to the nearest river and back? So what are the alternative means of doing things? So overall, I'm really impressed, and those were the only few remarks. And just to encourage you that you have chosen the best profession in the world. There is nothing better in life than doing what you're doing here. Continue to perfect this. Believe me, you will never regret it. Thank you.
Thank you. Thank you so much, colleagues. I'm sure I'm not your favorite person at the moment. But unfortunately, we have to prepare you for the profession. And I want you to all acknowledge that you are winners. The fact that you are here, you've already made it. One wise man had said that a journey of 1,000 miles begins with a single step. And I believe this is the first step of many that you are going to take. And an overall impression of your submissions, and I said it yesterday to some of the participants. I know, Council, we may not look as bright as they think we are, but at least assume that we can read. Don't read for us. We have the heads of arguments before us. Just make your orals, at least make eye contact to avoid the reading, because once we ask you a question and you are reading, once you come back, you are off mark. But you have done well. Don't dislike me. I was preparing you. I always make a joke about my first appearance in court, that as I was sitting there, I wanted to interject the prosecutor, and then I raised my hand, and everybody in court was looking at me, what's wrong with this one? And after I left that court, my jacket was so wet, you would swear that I was in the shower. But overall, you've done well, and congratulations. No matter the outcome, just tell yourself that you are a winner. Thank you so much.
Wait. Right. Unisa Interregional Moot Court Competition 2023 hypothetical case. Constitutional Court of South Africa case number 001/2023 in the matter between Themba Maluleke, first applicant, Rosalind Diko, second applicant, Boti Poswa, third applicant, Gogo Mthembu, fourth applicant, Shiklini Msenge, community, fifth applicant, Shiklini Msenge, traditional healers group, sixth applicant, African Community Council, seventh applicant, and the President of the Republic of South Africa, first respondent, Minister of Mineral Resources and Energy, second respondent, Department of Mineral Resources and Energy, third respondent, Minister of Human Settlement, fourth respondent, Department of Human Settlement, fifth respondent, Bogang Municipality, sixth respondent, Iron Africa Mining Corporate, seventh respondent, Forceful Removers, eighth respondent. As I now move to reading the issues of the case. Issue 1, jurisdiction before the Constitutional Court. Issue 2, direct access to the Constitutional Court. The applicants are desirous of approaching the Constitutional Court directly without first going to the Supreme Court of Appeal. Issue 3, the constitutionality of the removal and resettlement of communities taking into account Section 25 of the Constitution. Issue 4, the obligations of the South African government and the ministers in as far as the right to human dignity to the cultural, religious, and linguistic communities of the affected individuals are concerned. Issue 5, the constitutional obligations of the Eastern Cape with regard to the provision of alternative housing. Issue 6, the protection of children's rights. And the last one, the admission of Save the Culture as Amicus before the court. Thank you for your time, ladies and gentlemen. To our participants, good luck. Thank you.
All right, thank you very much for that introduction. May I request that teams do introduce themselves? Sorry, it's Kolilehu Mkiti.
My name is Musoke, M-U-S-O-K-E.
Can you say your surname again? Fonot. Thank you. And for whom do you appear? Thank you.
Good day, Justices. My name is Mampo Le Ntswane. Le N-T-S-O-A-N-E. Yes, please, the Court, Justice.
I assume you appear for the respondent too. All right.
If it pleases the Court, my name is Chachi Matume Piladi. I confirm my appearance on behalf of the respondents.
Thank you. We may proceed.
Justices of the Constitutional Court, as alluded to earlier, my name is Xolile Mkiti and I appear on behalf of the applicants in this matter. Justices, this is an appeal from the Mthatha Division of the High Court. We approached this court on direct appeal on an urgent basis, and this approach is necessitated by the gravitas of the constitutional rights that are impacted in this present matter. What has happened essentially is that a private company has evicted an entire community, leaving them currently, as I stand before this court, without food, water, and shelter. This court, as the apex court and as the final arbiter, must come to the rescue of the applicants by not only restoring their rights, but by preventing any further infringement. Justices, there are 4 preliminary issues that arise out of this matter. Those are jurisdiction, locus standi, direct appeal, and urgency, and we number them in that order. On the first issue on jurisdiction, we submit that there are 2 legs an applicant may rely on to engage this court's jurisdiction. And those 2 legs are found in section 1763B of the Constitution, which tells us that this court may decide 1, constitutional matters, and 2, matters that raise an arguable point of law, which ought to be considered of general public importance, ought to be considered by this court. Justices, we rely on the first leg, namely that this is a constitutional matter. Earlier in my introduction, I stated that before I get there, what is a constitutional matter? Section 1677 tells us that a constitutional matter is any issue involving the interpretation, the enforcement, or the protection of the Constitution. Earlier in my address, in my introduction, I stated that in this matter, we seek to protect the rights of the applicant and enforce positive obligations of the state. So from the 3 key words that appear in section 1677, 2 of those words appear in our case, so therefore the jurisdiction has been fully engaged. On locus standi, we address locus standi in paragraph 13 of our heads, and we are of the view that the matter is crisp, and we provide a summary breakdown on which section 38 right, because all the applicants approach this court in terms of section 38 to enforce their rights. In summary form, 1st to 4th applicant rely on section 38A, 5th applicant on section 38C, and the 6th and 7th applicant on section 38E. This then brings me to direct appeal, which is the 3rd preliminary issue. In terms of section 1676B, when it is in the interest of justice, this court may hear a matter on direct appeal using Rule 19. Now, in United Democratic Movement versus Speaker of the National Assembly, this court confirmed that direct appeal was not there for the asking or there for the taking. One must prove exceptional circumstances before they may succeed on direct appeal. Now, these exceptional circumstances can either be in the form of urgency, public importance, or prejudice to the public interest. Now, we submit that anyone with a proper grasp of the factual matrix of this matter will not find it difficult to find that there is extreme urgency to hear this matter and have the matters finalized. It is of grave public importance that the Shiklinim community be rescued by this court in the shortest possible time, and it will be prejudicial to the public interest for the community to endure the current violations and hardships any much longer than is necessary. We also submit that the involvement of children heightens the exceptionality. On the issue of urgency, it is trite that the substantial or the primary investigation when determining urgency is the absence of substantial redress in the ordinary course. For the same reasons we proffer in our attack on direct appeal, we feel that we submit correction that this court ought to have the matter of urgency. Justices, here we are dealing with a matter of life and death, And that is not an exaggeration, because those children who die from extreme weather conditions, starvation or dehydration, will not get any, let alone substantial, they will not get any relief, let alone substantial relief in the ordinary course. That concludes my address on the preliminary issues, and then I will attack the issue number 4, which speaks to the obligations of the South African government and ministers, which we deal with in paragraph 54. Now, the right to human dignity, free practice of culture and religion are provided for at 2 levels. The first is the international level and at the domestic level. We invoke the international level by virtue of Section 38(1)(b) of the Constitution, which enjoins this quarter to consider international law. Now, South Africa is a signatory and has ratified many treaties that not only provide this right, but provide for a positive obligation. We rely, or we make mention of 2 of those treaties, the one being the International Covenant on Civil and Political Rights and African Charter on Human Rights and People's Treaties. Justices, 2 things are done by these treaties. On the one hand, the rights are provided for, and on the other hand, a positive obligation is placed on the state to respect, protect, and fulfill these rights. Same thing happens in domestic law. We know in Section 10, the right to dignity is provided. Section 31, the right to free practice of culture, religion, and linguistic association is provided. And then in Section 7(2), there's a positive obligation on the state, placed on the state to respect, protect, and fulfill these rights. Now that we have established this fact, Justices, that both international and the Constitution provide for the rights, and both correspondingly place a positive obligation on the state to respect, protect, and fulfill those rights. Now, the obvious and glaring...
Councillor, I don't mean to disturb you. I just want to follow you. Where on your heads are you?
We deal with this in paragraph 54, from paragraph 54 of our heads. Thank you. Now, once we have established this fact, the obvious and glaring question that ought to come to our minds is that if the state has a positive obligation to protect, fulfill, and respect its rights, why are the community members of Shitlinim Senge currently, as I stand here before you, without water, food, and shelter? The obvious and simple, straightforward answer to that, Justices, is that the government has failed to uphold its positive obligations that are provided for in international law and the Constitution. A private party has been allowed to evict children, elderly and disabled, leaving them with no food. The community is unable to enjoy their culture freely and religion because they've been removed from their land. Justices, the government's duty to protect, promote, and respect this right attaches to it by necessary implication the duty to conduct an efficient and effective investigation into any infringement of these rights. From the facts that are before us, there has been no single attempt by the government to conduct any such investigation. Alarmingly, which is also sadly, the government does not only fail to provide for the rights, they are actually opposing the assertion of these rights in litigation up to this court. Our learned friends on the other side will come before this court and will address and convince this bench to dismiss, on behalf of the government, to dismiss the rights that are being claimed here. We submit that this type of conduct by a state must be frowned upon, as it flies in the face of human rights protections and obligations that are provided for in domestic and international law. I move on then to the issue of the alternative housing, which is issue 5, which we deal with in paragraph 61. Housing rights, it is right, are provided in section 26(2), and there is a positive obligation correction in section 26 of the Constitution, and in section 26(2), there is a positive obligation on the government to fulfill these rights. Now, the government itself has recognized that it has a positive obligation and has responded to that by enacting the Housing Act, and under the Act, a housing code. Now, in 2.31e of the code, the government says that an emergency exists when the MEC, on application by a municipality or the PD, agrees that the persons affected, owing to situations beyond their control, are evicted or threatened with imminent eviction action, or from unsafe buildings or situations where proactive steps ought to be taken to forestall such consequences, close quote. From the above, and from the government's own acknowledgement in its own code, an eviction or illegal eviction is considered as an emergency housing issue. But beyond that, the government still has not done anything to rectify, even though they provide for a code that provides for such rectification. So therefore, Justices, we submit that the fact that the applicants find themselves currently without any shelter, even after the proceedings at the High Court, and this is a very important point because At the High Court, the government was cited as respondents, so it is 100% clear that they are aware of the situation, but even till now, up to this court, they have not only not provided for any of these constitutional rights, but they actually oppose them as respondents in this matter. That, Justices, brings me to the end of my address, and if I may be of no further use to the court, and if it pleases the court, I will invite my co-counsel, Mr. Fongwaka, to address the court on further issues.
Thank you, Counsel. I do have one question. Apologies. Counsel, let me bring you a step back to the issue of jurisdiction and local standing. Now, Counsel, I think we would agree that in considering the interest of justice, we need to consider the cost implications of litigating. And while I may concede that this court might be clothed with the jurisdiction to hear this matter, kindly address me on the cost implications of rather not hearing this matter at the SCA, given that the cost implications, or the scale rather, used to litigate would be substantially lower than litigating at the Constitutional Court. Thank you, Counsel.
Thank you, Justice. I will answer the Justice's question in two ways. The first one, when we think of the costs, we also need to, the point of departure should be the gravitas or the importance of the constitutional rights that are at stake and the urgency for them to be restored. We know that in S versus Makwanyane, this court said that the right to dignity and the right to life are the most important rights in the Bill of Rights because they are the source for the other rights. Secondly, litigating at the Supreme Court of Appeal might seem at face value that it provides cost savings, but at the Supreme Court of Appeal, there is a risk of the losing party appealing to the Constitutional Court and therefore exacerbating the costs that would have been, the matter essentially will come to the Constitutional Court anyway because it does have jurisdiction.
Are you? Sorry. Yes, Counsel, I just want to go to the same issue of jurisdiction, but I just want clarity in respect of the fact that you seem to acknowledge that the SCA would be clothed with proper jurisdiction to hear this matter. Why is this court your court of first appeal and not the SCA?
Justices, the answer to that, thank you for the question. We go back to section 1766B, which actually in the Constitution applies for the direct appeal. It says when it is in the interest of justice. So the hurdle that is placed by the Constitution is the interest of justice. We therefore submit that looking at the constitutional rights, the weight of the constitutional right that are affected in this matter, it is in the interest of justice, and there are exceptional circumstances which warrant a direct appeal. Because at the SCA, there is a risk, again, of losing. Either party might appeal, and we know that an appeal will suspend the judgment, which then leaves us in the same position.
This court has a process called reconsideration or rescission of judgment. So it does not seem that your worries are quite covered by coming directly to this court. What do you have to say?
Justices, the risk between an appeal and the rescission are so much lower because they are specifically defined ways in which you may, such as an error of the court. And it is doubtful that such legally and learned justices would make such an error. So the risks there are very minimal as opposed to an ordinary appeal.
Okay, I don't know how far your charm will get you, but last question. Regarding the issue of agency.
Yes.
You don't seem to, you seem to have relied on Rule 612 on your heads of argument for agency. Is that Rule 612 of the Uniform Rules?
Yes.
I see no mention of Rule 12 of the Constitutional Court. Would you like to address us on that?
I'm sure it is there, Justice.
Right.
We deal with it in paragraph 22,
right.
And we say we rely on Rule 12. Actually, Rule 12, 29, because 29 is what is the rule that imports the 612 from the Uniform Rules of Court.
Okay, I see it. Thank you very much.
Thank you.
Do you have any questions? Just before you.
Sorry to bother you. I just wanted to find out from you, when we read the facts of this case, what was presented to us was that there was forceful removal, and I see in your arguments you are making mention of evictions. I just want to find out from you that, do you know the difference between an eviction, the law that applies to evictions, and the one that applies to forceful removals?
Justice, for me, I do not see any difference legally in the two. A forceful removal and an eviction, an illegal eviction at that, has the same end effect. So there's no distinction that I can draw legally on those two words.
Thank you, Counsel.
Thank you.
You may call your colleague to come and take.
If it pleases the court, I'll call my co-counsel, Mr. Fongwaka, to address the court.
Good morning, Justices. My name is Lubabalo Fongoka, as it was alluded earlier. On the matter before the court, I will be appearing on behalf of the applicant. The issue in which I will be dealing with is the issue of the constitutionality of the removal and the resettlement of the communities, taking into account Section 25 of the Constitution. May it please the court, Justices, if I may proceed, I would like to, before I proceed with my argument, I would like to highlight 4 reasons why we submit that the removal and the resettlement of the community was unlawful, was unconstitutional and generally unlawful. First of these reasons is the extreme violation of Section 25, subsection 1 of the Constitution. Secondly, is the violation of Section 26, subsection 3 of the Constitution. Thirdly, is the violation of the ACC's Constitution. And fourthly, is the non-consideration of reading the Mineral and Petroleum Resources Act together with the Interim Protection of Informal Land Rights Act. Further, Justices, if I may proceed, before going into detail on the reasons, let's first define as to what kind of the occupiers in the matter before the court are we dealing with. Are we dealing with unlawful occupiers of the land or something else? In our respectful submission, we are of the opinion that the applicants in the matter before the courts, they are lawful occupiers of the land in question, as opposed to unlawful occupiers of the Shiklenemsenge community. The crucial or the major question that the court needs to ask, taking into account my submission to the court, is how do the people of the Shiklenemsenge have acquired this right in question? That question could be answered by taking into account the prescript of the EPLR, which is Interim Protection of Informal Land, which is, I would like to direct the attention of the court to Section 1, subsection 1 of this Act, which provides for the definition as to what constitutes an informal land rights. Section 1 of this Act, Justices, I quote, is clear that, which is a Romani figure 3. The definition of a community, according... Pardon?
On which page of your heads of arguments? We want to follow your argument.
On page 31.
It's paragraph 31. Page
Paragraph 31, sorry. Thank you. So I quote, a community means any group or portion of a group of a person whose right to land derived in terms of the shared rules which govern or which determine an access to land. Close quote. This section went further in Roman figure 3 to define as to what constitutes an informal right to land. According to this act, it is clear that it is the use of, an occupation of, access to lands in terms of any tribal, customary, or indigenous law or practice of a tribe. And the Romani figure 2 states that the custom, usage, or administrative practices in a particular area or community where the land in question at times is vested. So, taking into account this provision, Justices, we submit that the applicants are informal right holders of this property through the customary law setting. As it is clear from the facts of our case that their ancestors, they've owned this land since 1800 years ago. So further, Justices, it must be clear that this is the only act that regulates the deprivation of a community that is held in such a basis. In terms of Section 2 of this Act, subsection 1, I quote, "It is clear that subject to the provisions of subsection 4 and the provisions of the expropriation of Act land or any other law which provides for informal right to land without his or may not be deprived of informal right without his or her consent." Further, subsection 2 states that where a land is held on a communal basis, a person may, subject to subsection 4, be deprived of such land or right in land in accordance with the customs and usage of such a particular land. So, Judges, what is clear from the fact of this case is that there was no consent that was obtained by the respondent, and this is clear from section 2, subsection 1 for pillar that the removal to be consistent, it must be in accordance with the customs and usage of this particular community, as contemplated in terms of section 2, subsection 2, which speaks to the violation of the ACC's constitution. In terms of the ACC's constitution, Justices, it states that for any decision that affects the ability of the community to live on the land free of an undue influence, there ought to be a quorum of 4 members concurring together on a decision, on such a decision. So, Justices, this is how I will conclude my argument.
Okay. Let me just check with my colleagues if they have any questions before you leave.
Were you done with your presentation?
Yes, because of the time.
You do.
Thank you,
Thank you.
Apologies. Come close. Thank you very much, Counsel. Counsel, would you kindly address me? You seem to suggest that the mining right in possession of the respondent, you seem to question its validity. And my question to you would be then, or rather you seem to question how it is acquired, therefore its validity. My question would be then, what steps have you taken to dispute its validity, if that is indeed what you are disputing, as there are remedies in terms of the MRDPA? That's my first question, Counsel. My second question, based on your submissions now, what you seem to be describing seems to be that your clients have been spoliated, but you don't seem to be making arguments in that respect. Can you kindly address me as to why this is not a spoliation application, given the submissions that you have made? Thank you, Counsel.
Thank you, Justices. Justices, the spoliation order should be applied for the spoliation order. That would delay the relief in which we sought to the court. Simply because when one applies for a spoliation order, the court is not necessarily investigating on the merits of the case. Instead, it only grants a declaratory order that such a conduct must come to an end, of which the relief in which we seek in this court is the permanent relief in which to enable our clients to come back to their land in which they belong to. I'm not sure if that answers your question, Justice.
Well, Counsel, the spoliation order can be brought, and you are entitled to request interim relief in terms of the spoliation order, in which will be binding and will be a return date will be issued to the effect wherein that order will be either made final or will be dismissed. So just to clarify that you can bring a spoliation application and an order be granted, an interim relief be granted in that respect.
Justice is taking into account, my apologies, taking into account the matter before this court and the rights in which are implicated in this right. There is children in this case. So Justice is an interim order. It's not going to be offered satisfactory to our clients, Justice. So you want a permanent relief that there must be no mining rights in the community of Shitlenemseng without the obtainment of the valid consent from the community.
I'll leave it there. Thanks, Counsel.
So.
Thank you very much, Counsel. You may call your colleague.
Also, Justices, if I may be of no further use of this court, I would love to invite my co-counsel, Mrs. Museke, to deal with the remainder of the issues. May it please the court.
Very well.
Afternoon, Justices. My name is Violoetu Umusoke, and I am appearing before this court on behalf of the applicant. I will deal with two substantive issues, and that is the issue of the protection of the children's rights. I will also deal with the issue of the admission of Save the Culture NGO as Amicus, and I will conclude the submissions for the applicants for the day. With leave of the court, if I may continue. Justices, along the Constitutional Court rules that have been established by my co-counsel, the respondents are also obligated to respect and to protect the children's rights. The forced removal of the children of this community from the land in question is a violation of the Section 28 enshrined constitutional rules, constitutional rights, which protect children from protect children from maltreatment, abuse, neglect, further guarantees children to the rights to education, healthcare, and social services. Section 28, subsection 2 of the Constitution states that a child's best interests are of paramount importance in every matter concerning the child. On paragraph 70 of the submission, Justices, Section 7 of the Children's Act, which was enacted to give effect to the Section 28 rights of the children, lays out in detail what is considered to be in the best interest of the child, or the factors that ought to be considered. And these include any change in the child's circumstance, as well as the child's physical, emotional security, and his or her intellectual, emotional, social, and cultural development as important. Justices, in the case of South African Informal Traders Forum and others versus City of Johannesburg and others, which is a case where informal traders were evicted from the city center as a part of a clean sweep initiative that was initiated by the then mayor. Muslinika ACJ made a very important link between the ability of their parents to earn a living and the impact that it has on their rights. Justices, Muslinika ACJ stated this, and I quote succinctly, that many of these people who were removed have dependents who are children who have suffered hardship as the city denied their breadwinners lawful entitlement to conduct their businesses. He further went on to say that the city's conduct has a direct and ongoing bearing on the rights of the children, including their rights to including their rights to basic nutrition, shelter, and basic healthcare services. Similarly, Justices, in this case, the first and second applicants are fourth generation farmers who rely on the proceeds of their vegetables to provide for their children. And it should be seen in the same light that the denial of their method to earn a living has a direct impact on the rights of these children to basic nutrition, shelter, and basic healthcare services. Justices, in Aronsa versus Aronsa, the court cited the importance of considering the best interest of a child in any matter that involves an eviction. To succinctly put it, the court said that had the Kota Kewell, who had provided or granted the eviction order, do a proper inquiry, they would have seen that the eviction order would have rendered the applicant and her children homeless, therefore violating the children's right to access to adequate housing. Justices, there have been numerous cases in our jurisprudence that have given due consideration to the best interests of the child in denying mass eviction orders. And these include the Meme Akbar and another versus unlawful occupiers and others. And we have listed another case, and you will find that on paragraph 75 of our submissions. Justices, it begs the question, why is it important that courts consider the best interests of the child in such matters? Well, the answer is simple. There have been numerous studies that have been published by the likes of the American Academy for Pediatrics. One such was published in 2021 and is titled The Health Impact of Evictions. These studies, Justices, have proven that evictions have a direct impact on the children's health. They show that the stress, uncertainty, and material hardships that come with these forced evictions have a biological impact on the children's health, and the eviction leaves a mark at all development stages that proves to be even more damaging to children with special healthcare needs. This was confirmed in other studies as well, which have been listed in paragraph 75 of the written submissions, but because of time considerations, I will not go there. Justices, in terms of Section 39, subsection 1b, as was alluded by my co-counsel, the international law commitments that bind South Africa include international treaties protecting the rights of children, and these include the African Charter on the Rights and Welfare of the Child and the Convention on the Rights of the Child. Article 3, which can be found in paragraph 77 of our submission, gives effect to the rights of the child that are contained in Section 28 of the Constitution. But not only does this treaty give effect, but it also places a positive obligation on the state to fulfill these rights. Justices, the removal of the members of the community, Shiklenim Sangha community, not only impacts on rights such as human dignity, but very importantly on their rights to enjoy the culture. There are international law treaties that protect the rights of children to enjoy their culture as well. Such treaties include the Convention on the Rights of the Child. Article 30 on that convention gives effect to these rights, and I quote, "Those states in which ethnic, religious, and linguistic minorities of persons of indigenous origin exist, a child belonging to such a minority or who is of indigenous descent shall not be denied the right, in community with other community members of his or her group, to enjoy his or her own culture." Now, justices, it is common cause that the land in question has a plethora of vegetation and minerals that is incorporated in the cultural practices of this community. So removing these children from this land in question will have an impact on that aspect of their culture. In closing, justices, it is clear that the Constitution, the Children's Act, and decided cases obligate the respondents to safeguard the rights of children.
I don't know if you're aware your time is up.
Yes, I just...
Okay. I don't know if my colleagues have questions. Do you have any questions?
My colleagues are making me look bad. I seem to be a complainant here. Ma'am, please do not understand this quote to be suggesting that the rights that you mentioned are not important. They really are. But I would like to also bring your attention to the fact that Eastern Cape is known to be one of the highest, if not the most, unemployment rates in the country. And I think it is common cause that any mining activities will likely increase job creation within the community and would, in the long run, be of benefit to the community. Can you kindly address to me whether that benefit does not outweigh the rights stipulated? If not outweighs, should it not be a factor that this court takes into consideration? Okay. Thank you, ma'am.
Thank you very much, Justice, for that question. Justices, considering the type of life that this community lives, it is deeply rooted in the ancestral way of living. So these are subsistence farmers who rely on what they plant and what they grow and on their livestock to provide for their families. So I think, justices, the assertion that formal employment is better than what they are currently having now may not be necessarily a correct assertion. I think it would be up to the community members, if they cope and they are able to use the current way of living and how they are currently providing for themselves, that is deeply rooted in their ancestral ways. I don't see how the respondents should interfere with that. It should be their choice how they decide to make a living.
Okay, Counsel, just two questions from me. One, I want to go back to the submissions you made in respect of children's rights, which seems to be, well, in your argument that they are compromised by the actions of the respondent or respondents. It does not seem clear to me what, in effect, you are asking us to do.
Justices, as is currently right now, these children are without shelter. They are missing instructional time at school. We are asking this court to reinstate this entire community, including the children, back to the land, and they will continue with their way of living. I'd like to highlight, justices, that Section 7 of the Children's Act, which was enacted to give effect to the constitutional rights of the children, specifically states that a drastic change in the situation of the child impacts the child. So this change in the situation where they have been accustomed to live in a certain way and they've been abruptly, in a violent way, being uprooted, has psychological impacts that are permanent and that might affect their development. So we are asking this court to mitigate that, to stop that, to return them to the land so that this drastic change in the situation does not have an irreversible impact on their psychological development.
All right. Thank you, Counsel. Last question. You were unable to get to address us on the admission of the Amicus curiae.
Yes.
But I'll ask you a question on that because it's part of your submissions on your heads of argument. The facts inform us that the Save the Culture is unregistered in South Africa. What should we make of that?
Justices, thank you very much for that question. Justices, the Constitutional Court rules that govern the admission of the amicus are clear. They are found in Part 5 of the Constitutional Court rules, and that is Rule 10. Sub-Rule 1 in the ordinary course, but because the respondents don't give us consent, we rely on Sub-Rule 4. There is no mention on the rules that are used to admit an amicus that they need to be a registered NGO here. Further, we submit, Justices, that the amicus is mainly assisting the court to come to its decision. It's not a party to the litigation. They do not have to have registration, or if they are, they don't have to have any registration in South Africa because they don't need locus standi to bring the matter forward. They are simply assisting the court with the information so that the court may arrive to a judgment.
All right. Thank you for that. And one of the requirements for admission of a party to the proceedings as an amicus curiae is that they must convince the court that their submissions are relevant. It does not seem on the face of it that we have been given their submissions in respect of what we must consider. Then my question is, what should at this stage, on the face of what you've submitted to us, compel us to admit them in the proceedings?
Thank you, Justices.
Sorry, before you continue, how do we stand to benefit, in simple terms, from Save the Culture?
The benefit of admitting Save the Culture as amicus curiae, Justices, is in the fact that they are well versed and they have a lot of experience with advising courts on such matters. So they have done it in numerous SADC countries before, so they have a lot of experience, and they specialize in the research and advocacy of cultural matters that are specific to Black Africans. And so we submit that they bring to this matter an element that none of the main parties bring, and they are going to play a rightful role, as was envisioned in the Helen Suzman versus McBride case, to assist this court to come to its decision because of this. Furthermore, they are currently in possession of audio and visual recordings that prove or that show the nature of the violence that and intimidation that the Shiklini Msenge community got or experienced during the forceful eviction, that will help sway this court to decide in favor of the applicant.
Thank you so much. And if we are with you, what should we make of costs?
Okay. All right. Our prayers, Justices, in terms of costs, should I give you the whole praise? Sorry, if it may please the court, just the costs.
No, just submissions on costs, okay. Briefly.
Justices, we ask that this court apply the bio-watch principle between the applicants and the state organs, and then party-to-party costs between the applicants and the private parties. So those are our requests in terms of costs.
Thank you very much, and you are excused.
Thank you.
Respondents, if you are ready.
Okay, you may proceed, ma'am.
Okay. Good day, Justices. My name is Letabo Mola, and I respectfully confirm my appearance on the behalf of the respondents, along my co-counsel, Ms. Lintwane and Ms. Chachi. I will be tackling jurisdiction, direct access to the Constitutional Court, and Lucas standing. Section 167, subsection 3 requires that a case must pertain a constitutional issue for it to be heard at the Constitutional Court. Secondly, it should raise an arguable point of law in terms of general public greater importance. However, our submission to this court in terms of jurisdiction and direct access is that, However, our submission in this court regarding direct access is that the court will be depriving itself of wisdom and ventilation of lower courts should they give the direct access and jurisdiction to our applicants. Not only that, the flow of judicial process is integral in the formation of legal jurisprudence, and this will be tempered with by bypassing the Supreme Court of Appeal. It is not in the interest of justice. But not only that, it is undermining and disregarding the Supreme Court of Appeal as not being a competent court of such matters. Meanwhile, in this case, the Supreme Court of Appeal should be dealing with this matter because it's a court that deals with matters of appeal at first more than constitutional court issues. Not only that, the need to save time and costs are issues molded by the applicants, simply because the alternative dispute resolution, such as mediation and arbitration, that they can consider before they could have taken the issue to litigation or to the Constitutional Court. Not only in that, in Dudley vs. City of the Cape Town and another, it states that the Constitutional Court emphasized on matters regarding it should be in the interest of justice for a certain court case to be heard in a Constitutional Court. And we believe that it's not in the interest of justice for the appellants to skip the Supreme Court of Appeal and come to the Constitutional Court. The Constitutional Court should be a court of last resort, not of appealing matters in most cases. If there is a certain court that can do that, we would prefer for you to use that court first before you want direct access to the Constitutional Court. The matter was first instituted in the High Court, where the bench ruled in the favor of the respondents. Should this honorable court rule in the favor of the appellants, what they will be demonstrating to the public is that they're making a mockery of our legal jurisprudence, and they're making a mockery of the High Court, making it look incompetent by ruling in the favor of the applicants. So however, they should retain the favor, retain the favor of ruling in favor of the respondents. The matter is not yet ripe at this instance and basis. The matter is not fit enough to be held at the Constitutional Court. Regarding the fact that Mr. Nkopodi went as further as sending an email of consent to the agreement, and sending that email of consent to an agreement introduces a principle of Pax San Servanta, that a contract should be honored at all time and all bases. Not only that, Mr. Nkopodi met the contractual obligation. Firstly, Mr. Nkopodi had the mental capacity to deal with these contracting parties because he's not mentally incapacitated and is not mentally impaired, but he's mentally stable. Secondly, Mr. Nkopodi was not held under duress or undue influence when he signed this contract. He had the presence of mind to know what he was doing, pretty much meeting the requirements of public policy in the matter of contractual agreements and obligations. Not only that, the IMC had good intentions with the contract. It was not in ultra virus, but it was in bona fide, simply because the IMC advocates strongly for economic growth and sustainable development in such a way that they're willing to build a mine to give the Shekinah Msingi community a decent salary. Not only that, sustainable development in such a way that they were willing to build a school at the Shekinah Msingi community and even make Mr. Nkopodi the director there. The IMC did their ultimate best to follow due process. However, the appellants were not as compliant. The IMC still advocate for the spirit of humanity because they were more than willing to give them a designated area to take them instead of being homeless. However, the applicants appellant suggested that they don't want to go to the designated area. But another thing that the appellant are forgetting is that the respondents have a mining right. The mining right gives them the right to enjoy and use the property of Shikini environment. However, even though they don't have the ownership, they have the right to use it and enjoy it, whether it could be building infrastructure or extracting minerals from the Shikini community. If the judges don't have any questions, I would love to proceed to my last issue, Lucas Dundee. The respondents has a standing to approach the court. Section 38, subsection A of the Constitution provides that anyone acting as a member as a member or interest or group or class of person has the right to approach the court, especially if they feel as if a certain right has been threatened. IMC is approaching the court to protect their rightful land, which they have acquired through a mining right to use and enjoy from the Shikini Msengo community. However, the appellant have a reasonable belief that it's their land. We're not disputing the fact that they have ownership, but they should also understand that we have a mining right that grants us the use and enjoyment of that land. We believe, as the respondents, that if appellants seek Lucas Dundee, they should go seek it at the Supreme Court of Appeal, not the Constitutional Court, because the Constitutional Court should be a matter of last resort. If justices have any further questions, if the justices don't have any further questions, I would love to see the podium to Ms. Lintwan.
Thank you, Counsel. Before you take a step down, I just have two questions, to be precise.
No problem.
One, is there a reason why your heads of argument are not numbered and the paragraphs are not numbered?
I think it's a typo. Sorry about that. Well, apologies.
Okay. Two, you mentioned that the agreement breached between your client and Mr. Nkopodi is valid because Pacta Sunt Servanda requires that parties who signed agreements voluntarily and willingly or must be bound by those agreements. Now, the facts seem to suggest that, in fact, the community seems to have said on the fact that Mr. Nkopodi never received a mandate to act on their behalf. How do we, is the agreement then between Mr. Nkopodi and your client valid? And how should we deal with that? The fact that there was no mandate.
The agreement, it is valid simply because when the IMC approached Mr. Nkopodi, they were of the impression, which is a reasonable belief that they should have, that Mr. Nkopodi is acting on behalf of the Shikini Msingi community. So anyone with a reasonable belief of being a rational thinker would have not known that Mr. Nkopodi is misrepresenting himself, and they would have not known that there's no mandate on their behalf, because firstly, before they were introduced to Mr. Nkopodi, they made their way to the village, and they told them that they're going to come here for consultation purposes. So the second time they came back, they were of the belief that the traditional council could have conveyed the message to Mr. Nkopodi. But not only that, if we go to the facts, when my apologies. If we go to the facts, 2.9, Mr. Nkopodi proceeds to say you've come to the right people for consultation before standing before you are the voice and the authority of Shikini Msingi community. And like I said, that's what we went with at the time as the IMC.
If I understand your submission well, you are saying that at the time you had a belief that he had the mandate.
Yes.
But now you know he didn't. So what should we make of the validity of that agreement?
In terms of balancing probabilities, this would definitely mean that the Shikini Msingi community and the IMC will have to set a date for another consultative process to speak about this.
So there was no valid agreement?
My apologies?
So there was no valid agreement at the time of conclusion of the agreement?
Yes.
Thank you.
Thank you, Council. I just have one question for you in relation to jurisdiction. I just want to make sure that I understood you correctly. Are you saying the Constitutional Court does not have jurisdiction to hear this matter, and it is the Supreme Court of Appeal that has jurisdiction?
We are not disputing the fact that the Constitutional Court can hear such matters, but we are saying that instead of the appellants making their way straight to the Constitutional Court, they should revert back to the Supreme Court of Appeal, because they also have the competency to hear such matters. But anything, because this matter is of appeal, and the Supreme Court of Appeal usually deals with matters regarding appeal, it would be like the most competent court for them to engage instead of engaging the Constitutional Court. But however, we also would have loved for them to engage the Constitutional Court based on it being the last resort that they've made the way to the Supreme Court of Appeal, and the judgment was not granted in their favor.
Thank you, Counsel. Ma'am, based on the pleadings before us, there's nothing that suggests that there was an eviction order or an order equivalent to that authorized you to conduct forceful removals. And you seem in your submissions to suggest that you, as custodians of the mining right, were therefore entitled to forcefully remove the commuters, therefore. Are you suggesting to this court that your mining right supersedes the applicant's rights to not be forcefully or illegally removed from the land? Thank you, ma'am.
Thank you for the question. We are not suggesting that our mining rights are superior to the right to property, but what we are suggesting is that as much as we are upholding the legislation on the appellants, the same legislation should be upheld on us, because we have a right in terms of the MPRDA. So as much as we're holding the legislation, the Constitution and legislation on their part regarding Section 25, subsection 1, that they have the right to property, we would like to also believe that, as the Honorable Court, you should take into consideration that we also have a mining right to mine there.
No further questions. Thank you, ma'am.
Oh, thank you.
Thank you. You may call upon your...
I would love to cede the podium to Ms. Lintwan.
Could I just gather before you begin? What is your surname? Double M? Thank you.
Good day, Justices. My name is Mampo Maida Lenswane. I intend to demonstrate the constitutionality of the removal and resettlement of the communities, taking into account Section 25 of the Constitution. I intend to highlight the obligations of the ministers and the South African government in as far as a right to human dignity, to cultural and linguistic communities of the affected individuals are concerned. I intend to demonstrate, my apologies, Justice, I intend to demonstrate the constitutional obligations of the Eastern Cape government with regards to alternative housing. Justices, may I humbly request to rectify a mistake that my learned colleague did in her oral submissions before I proceed with my oral submissions. Justices, I need to rectify and withdraw her statement with regards to Ms. Nkobodi's consent. Ms. Nkobodi's consent is valid in the matter because we have that valid consent. The reason why I'm saying that is because we were, the clients, my apologies, our clients were misinterpreted in the matter, Your Honorable Justices. And Mr. Nkobodi was in actual authority because Mr. Mpikwa Anga is the one who delegated the powers to Mr. Nkobodi to be the chairperson. And if they knew the appellants that Mr. Nkopodi is incompetent, then why would they allocate him to be the chairperson of that meeting? Mr. Nkopodi, if he was of the knowledge that Mr. Nkopodi is indeed incompetent, as they say in the facts of the case, then he should not have delegated the powers of being a chairperson to Mr. Nkopodi. Therefore, we submit that Mr. Nkopodi's consent was valid. If the Honorable Court has no further questions, may I proceed with my oral submissions, as the Court pleases. The IMC justices permitted the IMC were permitted, justices, by Mr. Nkopodi to operate on the land. Our submission is that the Honorable Court must allow the IMC to operate because they had a contractual agreement with Mr. Nkopodi, which was bona fide. There's no way the IMC would have known that Mr. Nkopodi wants sustainable development for his own self-interest and not the community at large. The IMC and the community have a duty to honor the Pacta Santa Servanda principle, which is a contract must be honored in the matter. Furthermore, the
Excuse
IMC
me,
did...
Counsel, I am sorry to interrupt you. I want to ask you as to from where in your heads of argument are you? I'm not sure if you'll be able to guide us.
My apologies, Justice. I will not be able to drive you with regards to the heads because they are not numbered. I think it's an error, a technical error. My apologies, Justices. My apologies.
Okay, so we'll listen.
Okay, my apologies. May I proceed?
You may.
Yes. Furthermore, Justices, the IMC did not use undue influence or intimidation towards Mr. Nkopodi. Mr. Nkopodi consented willingly. The IMC justices did everything by the book. They did not instantly remove the community from their land. However, it is evident in the facts of the case that they requested the community to move to a designated area and not the streets. And nothing, justices, barred or is preventing the community to move or relocate right now to city center. The relocation settlement agreement has already been concluded, signed, and authorized by Mr. Nkopodi. The applicants further raised that the graveyards being exhumed, it would be a great concern. We submit that the relocation settlement agreement does cater for their complaints and their needs in this matter because it states that the bodies would be exhumed to the nearest city center or rather an alternative graveyard. The community in this matter, justices, is in the streets willingly because there's nothing that's preventing them from relocating to city center. In terms of Section 25, subsection 2A of the Constitution, the removal was for public purpose and public interest in the matter. They will be able to farm, sell vegetables, livestock, make and sell their poultry to a large population. They will generate more money and they will be able to send their children to better standard education. For instance, Rosalind Diko and Themba Maluleki in the matter. In terms of Section 15 of the Constitution, subsection 1 to 3, the community have the right to freely practice religion, belief, and opinion. The community will not be blocked, justices, from practicing their traditional and cultural practices. Justices, I would also like to raise a point that the appellants raised, that the traditional and cultural practices will not be practiced or celebrated in city center. We argue, or we submit rather, that they will still be celebrated because in terms of Section 30 and Section 31 of the Constitution, it says everyone has the right to language and to participate in the cultural life of their own choice. I'll be specific, everyone, not everyone in the rural or everyone in the urban. It says everyone. In terms of, my apologies, the community, therefore, we submit that the community will not be blocked from practicing their traditional and cultural rights. And we are aware that there are certain practices that they cannot practice freely as they were in their ancestral land. However, we need to take notice of the fact that we cannot be exercising our rights in a manner that is inconsistent with any provision in the Bill of Rights. Therefore, if, for instance, they want to slaughter a cow or a goat in the city center, that will be considered as animal cruelty to other people. Therefore, we cannot, justices, exempt the appellants in this matter to do as they please and change the constitution as it is. They have to abide to the laws even when they are in the city center. However, there's nothing that the IMC that it can do with regards to that. However, the South African law does grant everyone to participate and celebrate their traditional and cultural rights in the matter. Therefore, we submit that the respondents deny all allegations made by the appellants. The respondents did not unlawfully deprive the applicants of their land, taking into account Section 25 of the Constitution. May I proceed to the next issue, Justices?
Yes, you may. Just be mindful that there's only 10 minutes remaining.
Okay, Justices. The respondents, justices, consulted with the applicants and in doing so, provided an opportunities for the community to grow. The removal and resettlement of the communities offers a wider opportunity for the cultural diversity. They rely on informal population. The population in the city is more larger than in the rural areas. This will give them more advantage to have more customers that will buy from them, more opportunities that will generate more income for them to sustain their families. The education justices will be more crisp. Their cultural and religious beliefs are also not barred from being practiced or celebrated in South Africa. The IMC justices in the matter are the ones who are wronged because legally they have been granted the right to mine. The fact of the matter is that the lawbreaker is not the South African government, but the appellants themselves. Their ancestral beliefs were considered. They understood that having access to the graveyards is an important practice. Therefore, they offered that the bodies be exhumed in Section 30 of the Constitution. And justices, we need to take note of the fact that exhuming bodies is still a suggestion. If our clients really disregarded their traditional and cultural rights, then the bodies would have been exhumed yet, but they are not. This is still a suggestion, justices. We submit, justices, that their traditional and cultural rights were protected in the matter. If there are no further questions, justices, may I proceed to the next issue that pertains to alternative housing? As the court pleases. Justices, the lawbreakers in the matter is not the South African government, but the applicants themselves. They deprive themselves of their right to adequate housing. The IMC provided shelter which is more secure and safe. This is evident in the relocation settlement agreement that was concluded. We submit, justices, that the ACC and the traditional leaders of the community should then provide shelter for the community, not the IMC or the government, because there is already alternative accommodation that is allocated for the Shikini Msenge community, and nothing prevented the community from being relocated there. It is evident in the effect of the case that they said and they requested that the community should be relocated to a designated area and not the streets. If there are no further questions, and if it pleases the Honorable Court, may I cede the podium to my...
Thank you, ma'am. I only have two questions. Firstly, in respect of the, excuse me, I don't know why this word tangles my tongue, exhumations. I don't see any efforts, bona fide efforts, to consult the community or cultural experts to make sure that this process is done so in a manner in which gives dignity to the deceased and the family, so on. So what processes have you put in place to make sure that this process is not just a, by the way, let's move the remains to another place, but is done so in a cultural, observant manner and respectful to the dignity therein? That is the first question. The second question I have, ma'am, is with regards to the adequate or alternative housing that you have furnished. The housing relates to a city center hall. Your papers do not advise whether this housing alternative is an interim measure, as I think you would agree with me that alternative housing is not adequate as the legislature might have intended. In respect of the families that are being moved here also have issues such as livestock as well. Your papers don't take cognizance or address what will happen to those livestock and so on, but only speaks to having arranged alternative accommodation in the form of a city center hall. Thank you, ma'am.
Thank you for the question, Justices. Justice, I'll start with the first question that you raised about exhuming bodies. We are aware that we need relevant authorities, the National Health Act in the matter, to authorize the disposal of bodies. However, we need to take note of the fact that we were not too quick to act, therefore, and it was still a suggestion. We did not dispose the bodies as yet. The Shiklini community members were catered in the matter because now being included in the consultation indicates that the IMC did not disregard their traditional and cultural practices. They did consult with them, and they did wait, and they're still waiting on the approval to exhume the bodies. There's no way in the fact of the case where it states that the IMC truly indeed exhumed the bodies of the ancestors or of their gods. They respected and protected the community as a communal. And again, the second question, Justice, was about the Justice. May you please repeat the second question?
Thank you, ma'am. My second question was with regards to the adequate housing aspect of your argument. You seem to suggest that adequate housing was provided in the form of City Hall. So what I'm asking is, what is going to happen? Is this an interim measure, firstly? And secondly, what do you say in respect of the livestock of the community members and other? I don't think staffing community members in a community hall equates adequate housing. Thank you, ma'am.
Thank you for the question, Justice. Justice, the reason we are saying that the lawbreakers in the matter are the appellants themselves and not the South African government is because they are refusing to go to the city center. And there's no way in the facts of the case where it says that they moved to city center and they were also forcefully removed from that place. We submit that it is the duty of the ACC and the traditional leaders to provide for housing, because there's already housing that is designated for them. However, they do not want to relocate to that place. Therefore, if the ACC and the traditional leaders believe that they can get a better place and not move to city center, then we are not in their way, Justices. Because, Justices, remember, in terms of the Mineral Petroleum Resources Development Act, we are following the rules with regards to the removal of the communities. And we are following the rules with regards to consulting with the communities and obtaining a valid consent from the communities. We are aware that our clients had to provide for accommodation for the removal of the Shiklini community members. Because if we did not do that, if we do not allocate them the place, city center, I believe that the South African government or the South African law, in specific the PI Act, would have sent our poor clients to jail. Therefore, we state that in terms of Section 5 of the Mineral Petroleum Resources Development Act and Section 5 subsection 13 3 and 4 of the Mineral Petroleum Resources Development Act, that we complied with the consultation requirements in terms of that act, because we consulted with the relevant traditional authorities. What happened between Mr. Angam Pikwa and Mr. Nkopodi has nothing to do with us justices, and we and the IMC would have not known that Mr. Nkopodi is malicious in the matter and he wants personal benefits or he has a personal interest in the matter instead of the community at large. We submit that the traditional leaders and the ACC should then provide alternative accommodation, since then they do not want to relocate to the allocated area.
Thank you. Just a quick follow-up. Did Mr. Nkopodi have, or did he not have, the mandate from the community to become a director of the school for the blind?
Thank you for the question, Justice. Mr. Nkopodi was given a mandate by Mr. Anga Mpikwa in the matter, Justice. He was allocated the powers of being a chairperson in the matter. However, with regards to the content of him being the director of the blind school, it's not stated. I'm not going to lie that it was. But Mr. Anga is a respected traditional leader who is of high caliber in the community. And I believe that if he knew or he understood the severity of this meeting.
Excuse me, Counsel. My question was very simple and your time is up, so I don't want you to go on and on. So your answer to my question is no. That was not part of the mandate of the community for him to become the director.
Correct, Justice.
Thank you.
Correct, Justice. If
Counsel, your time is very limited. I'm going to request that when you respond to my questions, you try to be as brief as possible. I'm
Okay,
going
Justice.
to go to your heads of argument as you are counsel making a case before us. I would start with what you stated here in your heads to say, if the court grants the interim relief that is sought by the applicants, it will be a mockery of our hard-earned democratic and legal process and legislature in terms of the Mineral and Petroleum Resources Development Act. Now, I want to take you to your heads, read with the facts. Your clients, IMC, they had to employ the services of forceful removals to remove the community. And in your heads of argument, you made reference to a case that this court dealt with, the case of Maledu and others versus Itireleng Bakgatla Mineral Resources. Do you or can you confirm at this moment that you followed the law as you are suggesting? Did you follow the provisions of the MPRDA?
Thank you for the question, Justice. Justice, we did follow the correct procedures in terms of the Mineral Petroleum Resources Development Act. Justice,
you have a court order to remove these people when you made services of this forceful removal.
There was no court order evidence.
Thank you.
Oh. As the court pleases, and if there are no further questions, may I cede the podium to my co-counsel?
Very well. You may.
As the court pleases, Justice.
Good day, my justices. I hereby, Judge Matume Peladi, confirm my appearance on behalf of the respondents. I'll be tackling issue 7 and 8 together with prayers. I'm going to be brief and short at the same time due to time. I would like to submit that the IAMC came up with a request to the community to move to the city center as their way of providing shelter, which is the socio-economic needs of the kids. Section 29, subsection 1 of the Constitution provides that everyone has the right to education. The IAMC building the school for the blind, as per Mr. Nkopodi's proposal, would grant the children of the Shikinye Msenge community a better education, which is in exercise of the right to education. And them being moved to the city center will help them have a gist of a standardized education within that area. I strongly believe that Section 28, subsection 2 of the Constitution was highly considered when Section 29, subsection 1 of the Constitution was put in place during the relocation settlement agreement. We are sad that...
Excuse me, Counsel. I understand that your time is, as the team, was exhausted by your colleague. So we're going to give you 5 minutes for you to wrap up all your arguments.
We submit that as the IAMC or the respondent to this matter, that the protection of children's rights was taken into consideration in this regard. If it pleases you, my justices, may I move to my next issue. In terms of Rule 10, Sub-Rule 1, the applicants did not meet the required the requirements of an admission as an amicus. So we oppose the silviculture being admitted as an amicus curiae in terms of this rule, because in paragraph 2.14 of the facts of the matter, this amicus it's been there not to assist the entire case, but directly to assist the applicants. Therefore, we plead with the court that that silviculture should not be admitted as an amicus in this matter. If it pleases the court, may I proceed to my prayers. We pray that this honorable court upholds the judgment of the first court, which is the High Court in this matter. Then we be granted the space and the opportunity to mine on the land, as we have the mining rights in this matter. And furthermore, the rest of the prayers are listed in the last page of the heads of argument. If it pleases the court, may I be excused.
It seems that I pressed you, so I don't want to be unfair. You still have a couple of minutes. If you feel there are points you want to make an emphasis on, please feel free.
Thank you, my justices. I'm fine with it.
Can I request the timekeeper to allocate you 10 minutes? The reason for that, you can start from the beginning. We have to assess you as an individual. So with what you have presented so far, we do not believe that it's fair. So you can be allocated your 10 minutes from now. Thank you.
Good day, my justices. I hereby confirm my appearance on behalf of my client, who's the respondent in this matter. My justices, the IAMC came with a request to move the people, the community of Shitlinyimsenge from the land that they were supposed to do mining on to a designated area, putting into consideration the socio-economic needs of the children of Shitlinyimsenge, which involved the right to shelter and the right to education in terms of Section 29, subsection 1. The IAMC, building the school for the blind, as per Mr. Nkopodi's proposal, will grant the children of Shitlinyimsenge the opportunity, my apologies, the opportunity of exercising their right to education, as the right to education or education itself plays a vital role in uplifting people from poverty, empowering women and children, and promoting human rights and freedom, and democracy. The relocation of children to the city center will give the children a better education or better standardized education. Section 28, subsection 2 of the Constitution was highly considered when Section 29 of this Constitution was put into place during the relocation settlement agreement was being put up. According to South African Human Rights Commission, SAHRC, the fact that the best interest of a child is of paramount importance does not mean that they are absolute. And the interest of a child does not override other consideration. In the case of Nandundu and others versus Minister of Home Affairs and others, it was held that the interest of the child, jurisprudence provides that the rights of children do not subsede other rights, as the right can be limited. Section 36, subsection 1 of the Constitution, the limitation of rights in the bill. The interests of the children in this matter are not just, but they are prioritized. We assert the protection of children's rights has been taken into consideration throughout the process. The relocation settlement agreement included provisions for the welfare and well-being of the children as a member of the community of Shiqenyemsenge. The private company hired for the relocation was responsible for ensuring that children are not harmed and that their basic needs are met. Any allegations of harm or neglect should be addressed on an individual basis rather than a systematic violation of the children's rights enshrined in Chapter 2 of the Constitution. If it pleases the court, may I proceed to my next submission. The admission of silviculture as an amicus curiae. Rule 10, Sub-Rule 1 of the Constitutional Court Rules provides that any person interested in any matter before the court may, with written consent of all the parties, be admitted as an amicus curiae. We submit that our appellants did not actually, my apologies, we submit that we as the respondents, we did not consent to the admission. And on top of that, paragraph 2.14 clearly states that the amicus curiae, it being admitted in this matter, does not help the case, rather help specifically the applicants. So it's not going to be a good one for the case in general. It's one-sided rather the entire case. Therefore, however, we believe that the NGO does not have direct interest, rather substantial and both direct interest in this matter, and their involvement will be a waste of cost, resources, and time. The applicants have not yet demonstrated the need for silviculture's involvement, and their evidence and arguments can be presented without the NGO's assistance. Therefore, we submit that the silviculture should not be admitted as an amicus curiae. If it pleases the court, may I proceed to submit my prayers?
Yes, you may.
We pray to this honorable court that 1, the appellant be denied direct access to this honorable court and the matter be remanded to the SCA. The South African government, number 2, the South African government and the ministers have satisfied the obligation in as far as human dignity, culture, religious, and linguistic communities of the affected community is concerned. Number 3, that the Eastern Cape Housing Department does not have obligation to provide alternative because the IAMC has already done it. Number 4, the order of the High Court be upheld, which is the protocol, be upheld and not be overturned. And we, or our clients, be afforded a space to start with the mining operations. And number 5, civic culture not be admitted as an amicus curiae?
Thank you. I take it that you are not making any claim for costs?
No, I didn't.
Thank you.
Council, I will be very short. I heard you saying that the interest of the children do not outweigh any other interest. In this case, it means that the interest of the children do not outweigh your client's mining interests. Did you take into account the livestock that you want to move the applicants with when you were removing them, because you removed their livestock? Did you cater for their livestock to be accommodated in the city center?
Thank you, my justices. I believe everything has been put into place. The moment we thought of the removal of the people to the city center, the exhumation of the graves, even the livestock of the people will be given a designated area which they will be kept at. I believe there are farms that are owned by the government that will actually be able to accommodate the animals or the livestock in general, to say. Thank you, my justices.
Thank you very much. You are excused. Would the applicant wish to rebut? Please. Timekeeper, if we could allocate them 10 minutes for rebuttal. They say they only need 5, so if you could just allocate them 5 minutes.
Justices, the applicants made a number of assertions that we wish to attack, but if we attack all of them, then we would be here the whole day. So I will only attack a few. The respondents spoke about preferring the applicants to go to the Supreme Court of Applications, and we'd like to put it to the respondents, it's not a matter of preference. We have made a strong case on direct appeal, on locus standi, on jurisdiction, and on urgency. And the respondents have failed to attack any of the merits that have been brought by the applicants before this court. The respondents made an assertion that locus standi, or they have locus standi to bring this matter before the court, but we put it to them, it is actually the applicants who brought the matter before this court. So we don't understand where the locus standi would come from. They mentioned that we should seek locus standi from the Supreme Court of Appeal, and we put it to the respondents that locus standi is inherent, and we did put that in our submissions that Section 38 of the Constitution gives us locus standi, and we mentioned how each of the applicants have locus standi. They made assertions that their mining right supersedes the applicant's constitutional rights, which include the constitutional right not to be evicted without a court order. Yet, justices, they obtain this mining right using a subordinate piece of legislation to the Constitution, which is the MPRDA. Justices, it is common cause that the supremacy of the Constitution is unquestioned, as is it contained in Section 2 of the Constitution. Any other piece of legislation is subordinate to that, and any action that violates constitutional rules is unconstitutional. They conceded that there was no valid agreement between the community and the respondents, or valid consent that was given, owing to the fact that the quorum of the ACC was not met. Yet they are asking the applicants to utilize their alternative housing, which the applicants find themselves homeless because they evicted them without that required consent, which, justices, we can liken to the respondents requesting that the applicants eat fruit from a poisoned tree. It does not make sense. We are contesting the consent, yet we are at the same breath required to use alternative housing, that we find ourselves homeless because this consent was not obtained. Justices, the respondents have violated a number of the applicants' constitutional rights that we have put before this court. Yet they make very bold assertions that exhuming the bodies of this community's loved ones is a favor. And that is very telling of the respondents' blatant disregard to the constitutional rights of the members of this community. That statement alone is proof that the respondents disregard the constitutional rights of the members of this community. Lastly, Justices, we submit that the respondents failed to read the Constitutional Court Rules 10 beyond Sub-Rule 1, because we did in fact mention before this court that we did not have the required consent to have Save the Culture NGO be admitted in terms of Sub-Rule 1, and therefore we find recourse in Sub-Rule 4. We did mention that, we did acknowledge, and we do have recourse in Sub-Rule 4. So it means that the respondents stopped reading the Constitutional Court Rule number 10 at Sub-Rule 1, and they did not proceed and get up to Sub-Rule 4. Justices, in closing, this court's decision will not only determine the fate of the applicants, but will set a precedence for the balancing of economic development with human rights that will resonate well beyond this case. In rendering its judgment, this constitutional court must navigate the intricate fabric of constitutional values, international obligations, and the lived experiences of those affected. Ultimately, the Constitutional Court's decision should not only provide for immediate grievances of the applicants, but should also contribute to the nuanced and balanced jurisprudence that guides this nation towards a more equitable and just future. Justices, we submit that in this momentous juncture, the court's wisdom and integrity will illuminate a path forward that respects both the aspiration of economic progress without sacrificing the core principles of human rights and social justice. This is where we will end our rebuttal.
Thank you. Before you go, let me just verify if my sisters don't have any questions for you.
Yes. I don't have any questions except to say I'm going to reserve my judgment.
Okay, thank you.
Thank you. You are excused, and judgment will be reserved in this matter.
Thank you, Justice.
Thank you.
Please, the court.
Court adjourns. Thank you.
I now just need sheets for the sheets for the teams.
Oh no, how about Ray for it?
Team sheets.
Yeah, for the team, not
We
for
only have individuals.
Yeah, I think 6. Was this the last time? Yeah.
I can't go and get stress. May I be excused?
I have one judge.
You have one judge?
That's right. I have 4 judges.
So, I don't want to sit in the
I think Papa no thing.
For the same team.
In this court. Thank you.
It's Ms. Pagedi. I'll be your presiding judge.
Mr. Mafokwane, I'm the presiding officer.
We'll start with the applicants.
Justices,
Afternoon.
may it please the court.
My name is Lungile Khumalo, and I'll be appearing on behalf of the applicants.
Thank you, Ms. Khumalo.
As it pleases the court justices, I am Corley Clausen and I am appearing on behalf of the applicants.
Thank you, Mr. Clausen.
Corley Clausen, C-O-R-L-Y C-L-A-A-S-E-A.
Thank you.
May it please the court, justices. My name is Mr. Moashera Moashera, and I will be appearing on behalf of the applicants.
Mr.
Moashera, M-U-H-A-S-H-E-L-A.
Good evening, Justices. My name is Violwetu Musoke, Musoke spelled M-U-S-O-K-E, and I appear before this court on behalf of the respondents.
Thank you, Ms. Musoke.
This is the court. Good evening, Justices. My name is Lubabalo Fongwaka. On the matter before the court, I will be appearing on behalf of the respondent. May it please the court.
Thank you, Mr. Fongwaka.
May it please the court. My name is Olile Mgidi. I confirm my appearance on behalf of the respondents in this matter.
Thank you, Mr. Mgidi. Parties may hand over their heads of argument. Thank you, applicant. You may proceed. You must kindly please stick to your allocated time. There's Mr. Timekeeper there. Whenever he raises the placard, it means your time is over. Thank you. You may take the podium if you wish. You may address us from anywhere you feel comfortable, but the practice is that everybody has been addressing us from the podium.
May it please the court. My name is Lungile Khumalo, and I'm appearing on behalf of the applicant. The case before this honorable court is not just a legal one, it is also a moving illustration of the delicate balances that must be struck between the protection of human rights and economic imperative, particularly for the most vulnerable members of society. This case raises
an important question as to whether economic growth can ever be justified at the expense of fundamental human rights violation, especially those that affect indigenous communities. The first to 7 applicants are community members, not faceless entities out preventing economic progress. They are the embodiment of a community with ancestral ties to the land they live on, where they have grown their livelihoods. Where they have grown their livelihoods for generations. Their bond with this land is more than just economic. It is spiritual, cultural, and deeply personal. It supports their existence, tradition, and way of life. Justices, today I shall be dealing with urgency, jurisdiction, and direct access to this honorable court. Urgency. The applicants beg this case be heard on an urgent basis as the court intervened to the urgency and gravitas of the matter. Due to the circumstances of this case, it justifies the shortening of times and the non-conformity to Rule 12 of the Constitutional Court. If the said matter is not heard urgently, the applicant will not be afforded substantial redress at a later hearing. This is because there has been gross violation of the applicant's fundamental rights, which are set forth in the Bill of Rights, and any delay in the matter may cause irreparable damage to the Mshiklingi's community's land, dignity, and their ability to fend for themselves. Furthermore, the applicants in this regard argue that children's fundamental rights have been grossly violated upon. Section 28, subsection 1D of the Constitution states that every child has the right to be protected from maltreatment, abuse, degradation, and neglect. Section 28, subsection 1D also forms part of the non-derogable rights. Having that in mind, there has been documentary evidence that show that the 7th respondent have harassed and intimidated vulnerable people in the community. I shall be moving to jurisdiction and direct access. Section 167, subsection 3, 4, and 5 of the Constitution define the constitutional jurisdiction. Section 167, subsection 3, B grants the Constitutional Court's jurisdiction over constitutional issues as well as any other matter. Exclusive jurisdiction and confirmation proceedings are addressed in Section 167, subsection 4 and 5, respectively. The Constitution further states that national legislation or rules of the Constitutional Court must allow a person, when it is the interest of justice, with the leave of the Constitutional Court, to bring matters directly to the Constitutional Court or to appeal directly to the Constitutional Court from any other court. A constitutional matter includes any issue involving the interpretation, protection, or enforcement of the Constitution. The Constitution empowers this court to hear constitutional cases or cases that raise legal issues of public concern. This case falls under the jurisdiction of this court due to the violation of human rights outlined in Section 10, 25, 26, 28, and 31 of the Bill of Rights of the Constitution. In the matter of South African Traders Forum versus the City and another, it was determined that hearing an urgent
hearing an appeal on an urgent basis was in the interest of justice. Quote, if leave to appeal had not been granted, the applicants would have suffered severe irreparable harm. Applying the case at hand, this is a constitutional matter and must be heard on an urgent basis because the applicant's right to human dignity has been violated, and further action by the respondent will result in irreparable harm. Section 167, subsection 1, subsection 6 of the Constitution gives this constitutional court the authority to decide whether to hear appeals from any court on constitutional disputes in the interest of public justice, or rather, disputes in the interest of justice. There is no predetermined distinction between appealing and non-appealable issues, provided that the dispute is about a constitutional issue. This case is a constitutional matter because the right to human dignity has been violated. This is a constitutional matter, as stated in Section 10 of the Constitution. Members of this community were removed from their homes and left without livestock, food, shelter, or water, leaving them unable to fend for their dependents. Yes, I'm done.
I'm not sure if there are any questions from my colleagues.
Thank you, Counsel. I just want to check with you. Is your submission that this matter is urgent?
Yes.
Why then did you not realize the urgency by first approaching the High Court? Was it not urgent then?
We did approach the High Court.
Yes, but what I'm asking you is that was it not urgent when you approached the High Court and now you feel aggrieved with the outcome? And
No.
then now you require direct access?
No. We need substantial redress right now because children are without shelter, food, or water. So and their human dignity has been violated upon. And redress in the later stage will rather be not in their best interest.
Okay, granted, Counsel. You may proceed.
Thank you, Counsel. You may call your next colleague.
Thank you.
Justices, as it pleases the court, I am going to be dealing with the issue regarding the constitutionality of the forceful removal of the community, as well as the obligations of the South African government in regard to their obligations to the community. Then I will be coming back to deal with the conclusion after I've handed it over to my co-counsel. The constitutionality of the removal of the community from the Bukang region concerns Section 25 of the Constitution, which is specifically in regard to property. It is held by Section 25, subsection 1, that no person may be deprived of property except for in terms of the law of general application, and no law may permit the arbitrary deprivation of property. Section 25, subsection 9 holds that legislation should be enacted by Parliament. This legislation enacted is known as the Interim Protection of Informal Land Rights Act. Section 2 of the IPILRA holds that provisions, subject to the provisions of subsection 4 and the provisions of the Expropriation Act or any other law which provides for the expropriation of land or rights in land, no person may be deprived of any informal right to land without his or her consent. Then going on to subsection 4, for the purpose of this section, The custom and usage of the community shall be deemed to include the principle that a decision to dispose of any such right may only be taken by a majority of the holders of such right present or being represented at a meeting convened for the purpose of considering such disposal, and which they have been given sufficient notice of, and in which they had a reasonable opportunity to participate. In terms of Section 4, subsection 2 of the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act, written and effective notice must be given of the eviction proceedings at least 14 days prior to any hearing of the eviction proceedings. In light of this case, no eviction proceedings have been commenced, and thus the community did not have any notice of the eviction. The respondents seek to evict the applicants as unlawful occupiers in terms of subsection 4 and 5 and 6, section 4, subsection 5 and 6 of the PI Act. In the definition of an unlawful occupier defined in section 1 of PI is a person who occupies land without express or tacit consent of the owner or person in charge, or without any other right in law to occupy such land, excluding a person who is an occupier in terms of the extension of security of Tenure Act, and excluding a person whose informal right to land, but for the provision of this Act should be protected by the provisions of the Interim Protection of Informal Land Rights Act. Then we go to section 4, subsection 7 of the PI Act. It states there that that if an occupier has been living on the said land for longer than 6 months, their constitutional needs and rights should be taken into consideration. Section 4, subsection 8 of the PI Act empowers the court to evict an unlawful occupier once it is satisfied that the provisions of section 4 have been complied with. The community cannot be regarded as unlawful occupiers in this act. Said that thus the said eviction is not lawful, and it couldn't have been done lawfully even though. Section 26, subsection 3 of the Constitution states that no one may be evicted from their home or have their homes demolished without an order of court, after considering all the relevant circumstances. There has been no order of court made in regard to this. By applying Section 25, Section 26, subsection 3, the PI Act and the IPILRA, it is clear that it argues in favor of the applicants. It is reiterated that a written and effective notice should be given to the community prior to their eviction or removal. As per the facts of this case, no notice was given to the community, thus making the forceful eviction unlawful. In regard to the obligations of the South African government, the South African government and the ministers failed in their obligations towards the community. They deprived the community of their human dignity as per Section 10 of the Constitution, that states that every person has inherent dignity and the right to have their dignity respected and protected. When the community was forcefully removed from their land, their right to human dignity was violated. As stated in the case of South African Informal Traders Forum and others versus City of Johannesburg and others, found at paragraph 40 on page 11 of the heads of argument, in paragraph 31 of the case, people's ability to earn money and support themselves and their families is a critical component to the right of human dignity. As stated in Section 31, subsection 1 of the Constitution relating to cultural, religious, and linguistic communities, persons belonging to a cultural, religious, or linguistic community may not be denied the right with other members of such community to enjoy their culture, practice their religion, and use their language. The Shigini Msingi community's right to practice their religion and to enjoy their culture has been denied by forcing them from their land. This influences their ability to train and practice their traditions, since they do not have access to water sources such as river and ravines. The community also uses water as a spiritual element of connection to their ancestors. These ancestors are also buried on the communal cemetery grounds, and visiting them is an integral part of the community's traditions and practices and culture, which violates the premise of Section 31, subsection 1 of the Constitution. Furthermore, the process of exhumation and reburial of the mortal remains of a person from their final resting place is unusual, drastic, and traumatic to the loved ones of the departed. As per Section 20, subsection 1 of the Cemeteries and Crematoria Bylaw of 2009, it also states the conditions for exhumation. No person may exhume no person may be exhumed without written consent from the Premier, municipality, Provincial Department of Health, Administrator of Cemeteries, Municipality's Medical Officer of Health, or the South African Police. Thus, exhumation cannot be continued. As it pleases the court, I will now hand over to my co-counsel, if there are no further questions.
Counsel, I have one question for you. I just want you to clarify for me. Are we dealing here with your clients as applicants in this matter? Are they lawful or unlawful occupiers of this land?
They are lawful occupiers of this land because the municipality did know of them living there and their ancestors living there for 200 years plus.
Thank you. I'm not sure if any of the justices have a question.
Yes, I just have one question for you, counsel. It seems to me that you are suggesting to us that there has been no non-compliance with the exhumation of the bodies. Am I understanding your argument well? I'm reading particularly from your paragraph 42 on your heads of argument, aligning it with what you were suggesting to us, that there's no compliance with Section 36(3)(a) of the National Heritage Resources Act. Am I understanding you well?
Justice, that paragraph was disregarded as new information was made available to us.
Is it your argument that there has been non-compliance with exhumation of the bodies?
No, I'm not. That is not my argument. My argument is that when they suggested to exhume the bodies, they have not yet made any consent or have been given consent to exhume the bodies.
I think I'll leave it at that. Thank you.
As it pleases.
Counsel, maybe before you leave, and I'm traversing on what my colleague has asked you. Do you not think that the consent given by Mr. Nkopodi suffices enough for the bodies to be exhumed, as he now speaks for the community at large?
I do not think Mr. Nkopodi was in a lawful position when he did give the authority to do that.
Was he not acting as the leader?
He was acting as a chairperson, but not in a lawful manner. And also, when it came to the decision-making of such the decision that concerns the community, it is also stated by the ACC that the leader of the ACC, as well as 4 council members, must concur on the decision.
Thank you, counsel.
As it pleases the court, I will now be handing over to my co-counsel.
You may proceed.
Good afternoon, my justices. I'm Mr. Mwashia. I will be dealing with issue 5, issue 6, and issue 7. Adequate housing, as well known, is a fundamental right that is protected by our Constitution. We have Section 26, from Section 26, subsection 1 to Section 3, Section 26, subsection 1 provides that everyone has the right to access adequate housing. And the subsection 2 provides that the state must take all reasonable measures to ensure that the above right is realized. And section 3 provides that no one may be evicted or have their home demolished without a court order after considering all relevant circumstances. And it is clear from this case that they have been deprived of such right as they were evicted without any court order. Thus, the Msenge community were left without food, shelter, water, and it is clear that the state has the responsibility to provide such means. This is why we are of belief that Housing Act was introduced in order to ensure that these circumstances before this case are prevented or do not arise. If we look at Section 7, subsection 1 of Housing Act, it provides that the provincial government must do everything in its power to promote, facilitate the provision of adequate housing in its province, that is within its national housing policy. The case of Redmayne versus the Western Cape District, it provided that where the municipality permits people to remain in its property, and it goes as further as providing them with water, sanitation, and other service, it then tacitly agrees or consent to their occupation of that property. We can go as far as confirming this by the case of the government of the Republic of South Africa versus Grootboom, which provides affirmed that the state's obligation under the Constitution is one of providing adequate housing. Thus, the responsibility of providing adequate housing for the Msenge community falls within the duty of the Eastern Cape. Now, I will move on to the constitutional rights. Our Constitution takes the best interest of children at heart. The people of the Msenge community and their children were adversely affected by this matter. Their right referred to in Section 28 of the Constitution were violated. This is the result of them having been forcefully removed from their land. Section 28, subsection 1, paragraph C, provides that every child has the right to basic nutrition, shelter, basic health, care service, and social service. Then, by forcefully removing the community, the children or the children's right to shelter are being infringed upon. An unlawful eviction infringes on a child's right to housing, right to family life, and the right to stability and continuity. Housing is a basic human right, and children have the right to live in a safe and secure home. So here in this case, their parents were evicted. This then puts these children, or puts them at a risk of homelessness and insecurity. Additionally, family life is an important right for the children. And this eviction disrupted this family unit or these family units are in the Msishanga community. And it caused distress for the children.
5 minutes left.
Okay, thank you. Lastly, having stability, the children have the right to stability, continuity, and their right to lives. This eviction caused this instability. I will move on to the amicus. In order to admit, Save the Culture to be admitted as amicus, there is Rule 10 of the Constitutional Code that needs to be complied with. This section provides that an application to be admitted as amicus curiae shall briefly, and this is what the amicus is willing to do, describe the interest of the amicus curiae in the proceeding. It shall briefly also identify the position they are willing to adopt, also set out the submission they intend to bring before the court, and the relevance of their evidence before the proceeding. Thus, it is submitted that before the court can admit, or it is submitted before the court that admitting Save the Culture as amicus will assist the court due to their intimate knowledge to the issue in question, as well as their vast collection of evidence that is way different from any other party that is in dispute currently. It is submitted that it be admitted on the grounds of representing the community at large, as it pleases the court.
Counsel, I want to get from you, is your submission now that your clients are without shelter?
Our clients are left homeless.
Without shelter,
yes.
As you say. But if you look at the facts there on 2.12, it says that a settlement had already been concluded and signed, that the relocation settlement contains the following, and amongst other things, one, that the community should be relocated to the nearest city. Does that not state that they have a shelter?
It does state that they have a shelter, but if I can take the court also, there is a paragraph where it states that they were left stranded. I might not be in the position to show it. So that on its own just says that these people, they were just evicted and not taken care of in accordance to what it should have been done under the law.
Thank you, Counsel.
Counsel, just ask you one question. What is the role that is going to be played by this Save the Culture? From the evidence that you have submitted, from your own submissions, you have informed this court that this NGO, they have documentary evidence, audio and video recordings of the harassment and intimidation. Do you see this, their admission as a friend of the court, or they should actually be a party to the proceedings?
Definitely. They possess what could refer to as direct evidence. So this direct evidence could assist court in achieving what it is referred to as just and equitable.
But it is not the duty of the court to gather evidence, it's the duty of the applicants. Why did you not invite them as applicants to this case?
We did not invite them as applicants because under the rules, we were not of idea that it will be a problem to the court, as it has the power to and the discretion to determine how to admit an amicus.
Thank you.
I want to ride on the question of my colleague. I don't think you are doing justice to it.
Okay.
The question simply is that the amicus, the party that wants to join as an amicus, seems to be possessing evidence which it wishes to present before this court. The question is, would it not be appropriate that such a party who wishes to present evidence in court should be an actual party to the proceedings, as opposed to them being a friend of the court?
For the case of fairness, I am of the view that it is better for them to be admitted as amicus.
All right, we will leave it at that. And last question from me. Save the Culture is unregistered in South Africa.
Yes.
As an NGO. If we were to go with your argument and we admit them as a party to the proceedings, when they are not registered in South Africa, what would be their what would be the basis for us to admit them, given the fact that they are not a registered organization in South Africa?
The basis of them being admitted is that of them. Let me read the quote on the grounds that they are representing the interest of the community at large, and for the fact that they possess evidence that would have helped the court reach a decision that is fair.
So in other words, their registration is irrelevant?
Their registration is a matter of dispute that this court could hear and decide in accordance to its discretion.
Okay. Lastly, my brother asked you earlier, or rather directed you to a paragraph that speaks about, it's paragraph 2.12, that says the community should be relocated to the nearest city center. And his question was that, do you agree that therefore there is shelter? You referred us to, well, you couldn't pick up the paragraph, but it's paragraph 2.13 on the facts, where you said it says that the community was left stranded without shelter, food, and water. I just wanted to assist in referring to the paragraph that you wanted to refer to. Am I correct in saying that it's paragraph 2.13?
Yes, you are correct.
Thank you.
Thank you.
Thank you, applicant. You are excused for now. We will give the respondent opportunity.
As it pleases the court.
Thank you. Respondent, if you are ready.
Justices of the court, if it may please the court. My name is Xolile Mkidi, and I appear in front of this honorable bench today on behalf of the respondents, and I will address 3 topics. And those are the preliminary issues, issue 4, and thereafter issue 5. Before I address the topics, justices, I need to, from the get-go, lay out that as the respondents at this point, we are not sure of the status of the occupiers that we are dealing with. In response to a question from the justice, second counsel for the respondent confirmed that they contend that they are lawful occupiers. But a substantial part of the address that the counsel made to the court dealt with the PI Act, which we know applies to unlawful occupiers, and the definition of unlawful occupier specifically excludes anyone with an informal land right in terms of IPLR. So at this point, we are not sure, are we dealing with informal land right holders, or are we dealing with unlawful occupiers in terms of the PI Act? Nonetheless, there are 4 preliminary issues that arise in this matter. Those are jurisdiction, locus standi, direct appeal, and urgency. On the first 2, we are with the applicants, and those are jurisdiction and locus standi, and therefore we shall not address the court on those as there is no dispute. What then remains is direct appeal and urgency. It is tried that section 1676B provides that when it is in the interest of justice and using Rule 19, an applicant may appeal directly to this court. Now, this court has dealt with the application of section 16B and more particularly the interest of Justice Hurdle in the case of member of the Executive Council for Development Planning and Local Government Gauteng versus Democratic Party and others. In paragraph 32 of the said judgment, Chaskalskin P. provided as follows, and the bench will find this direct quote in paragraph 11 of our heads. And I quote, "In deciding what is in the interest of justice, each case has to be considered in the light of its own facts. A factor will always be that direct appeals deny to this court the advantage of having before it judgments of the SCA on matters in issue. Where there are both constitutional issues and other issues in the appeal, it will seldom be in the interest of justice to that the appeal be brought directly to this court." Close quote. Two important things emerge from this passage from Justice Charles Kalskin P. The one is that this court has confirmed in this judgment that it sees that SCA judgments before it in matters in issue as an advantage. The second one is that where a matter concerns not only constitutional issues but other issues as well, it will seldom be in the interest of justice that the matter be appealed directly to this court. Now, the use of the word seldom suggests that an applicant must prove exceptional circumstances before they may succeed on direct appeal. This was confirmed in absolute terms in United Democratic Movement versus the Speaker of the National Assembly and others. Now, the question becomes, what are the exceptional circumstances that arise in this case that warrant a direct appeal? Now, when one looks at the facts, and having had the benefit of listening to our learned friends on the other side, it seems to us that the exceptional circumstances center around the current homelessness of the community. Now, it is tried that, and it has been already confirmed by the other side, that before the eviction took place, IAMC signed a relocation settlement agreement with one member of the ACC. Such settlement agreement IAMC has not reneged on, and as our client, the current stance is that it is still willing to honor the agreement, even if on a temporary basis, for the litigation to be ongoing and for the administration of justice not to be denigrated while the applicants still have shelter. We submit that the power to end the current crisis lies in the hands of the community. Our learned friends on the other side stated that the community is without shelter and water, and at the same time concedes that there is a relocation settlement agreement that is in place. Then the question becomes, why is then the community without shelter and water? The simple fact is that the community refuses to make use of the alternative shelter, and it seems to us unreasonable for the applicants to hold our justice system at ransom using circumstances they create themselves. Furthermore, this matter does not only involve constitutional issues, but has a bearing on mining rights, property law, and therefore we submit that this court would benefit greatly from the jurisprudence of the SCA in matters in question. On the issue of urgency, it is tried that the test is the proof of substantial, is the absence of substantial relief in the ordinary course, and we proffer the same reasons we deal with in direct appeal. For the same reasons, the urgency should fail. This then brings me to my substantive issue, which is issue 4, which speaks to the obligations of the South African government and the ministers. It is tried that the right to dignity, free practice of culture and religion, and linguistic association are all provided for at international and domestic level by the treaties and the Constitution, as we have heard. Now, justices, what we have not heard is that there is a particular standard that positive obligations of the state are judged against. And to answer or to find this standard, we ask this court to have regard to international law as enjoined by Section 39(1)(b). In this regard, we look to the European Convention on Human Rights and the jurisprudence of the European Court of Human Rights. There are two important things that have emerged from the jurisprudence of the European Court of Human Rights. The one is that obligations are not open-ended and are subject to limitations. The other is that positive obligations of the state must be judged reasonably and applied in a way which does not impose an impossible, disproportionate burden on authorities given the choices they face and given the unpredictability of human conduct. This standard has been endorsed by this court in cases like Carl Michel versus the Minister of Safety and Security. Now, we also submit that the positive obligations of the states are twofold. There is a legislative component to it, and there is a practical day-to-day running of the state component. Legislatively, The state has fully complied. It has enacted the MPRDA, which seeks to protect the rights of the applicant that they claim have been violated. It has enacted the IPLR, which protects this right. The second component, which is on the day-to-day running, to assess that, we need to go back and look at what has been the state's active involvement in this matter. When one looks at the facts, the state's active involvement ends at when the mining right is given. It is common cause that after the mining right is given, a period of 9 years passes. Due to a contractual dispute, the IMC cannot continue to mine. During the 9 years, the community settles in. At the end of the 9-year period, IMC approaches the community and links directly and has consultations directly with the community, and ultimately there is a relocation settlement agreement and an eviction. There is no single piece of direct evidence showing any state awareness of the consultations, settlement agreement, or the threat of violation. Justices, the problem with this case is that there are no sufficient factual, detailed facts on which to use to decide, using the appropriate standard, any state failures. By way of example, firstly, we do not know how much time passed between the eviction and the lodging of this matter at the High Court. Secondly, there are no facts which tell us when the matter was reported to the authorities, or if the matter was reported at all. Thirdly, for an example, let's say we want to take the SAPS into account for failing to fulfill its obligations. Firstly, all we know based on the facts is that the Siklenim community is in a remote area. We do not know where is the nearest police station, how well resourced is the police station, and we know that in the Eastern Cape there are examples of villages that are 100 kilometers away from the nearest police station. These examples simply seek to highlight that in the absence of detailed facts, crucial detailed facts, it is virtually impossible to assess state obligation reasonably and in a way that does not impose impossible and disproportionate burden on the authorities, given the choices they face and the unpredictability of human conduct. Whenever this court has pronounced on state failures or the state's failures to uphold positive obligation, it has done so on very detailed facts. Therefore, we submit, in the absence of such facts and considering the conduct of the conduct of the state before granting the mining right and the duty to exercise judicial constraint, this court should steer away from making any pronouncement of any state failures when there are no sufficient facts to do so. I will then move on to the issue of the obligation of the for provision of alternative housing, which is found in paragraph 70 of our heads. It is tried again that the obligation arises in section 26, and 26.2 places a positive obligation on the state. Again, Justices, we submit that there is a test, again, a standard which the obligation is to be judged against. And we find this standard in section 26.2, which uses the word reasonable and available resources. So the standard that the failure or alleged failure to provide alternative housing must be judged reasonableness and in terms of available resources. Now, when it comes to available resources, we know that the country is in a financial crisis. And we know now that after the budget, 2024 budget, the Eastern Cape is said to receive 761 million less in grants due to national cost-cutting measures. On the 13th of October 2023, the Eastern Cape government issued a provincial note outlining provincial cost-containing measures for the 2023-2024 financial year, and housing was impacted. Therefore, when using the available resources standard, it is clear that there are the government is in dire straits financially. Reasonability, just to conclude, we know, as the Justice has already alluded to, there is available shelter that is provided in the settlement agreement. Is it reasonable for a government that is with limited funds to provide to provide alternative housing where alternative housing already exists? So it's like providing alternative housing to alternative housing. We submit that that is totally unreasonable, considering that the state is already in dire straits financially, and there is no guarantee that the applicants will even use the alternative housing that the state should use, as they are denying or rejecting to use the current available housing. That, Justices, brings me to the end of my address, and if I may be of no further use to the court, and if there are no questions, I will invite my co-counsel, Mr. Fongwaka, to address the court on issues that remain.
I do not have questions at this stage. I'm not sure if any of my colleagues have questions.
Thank you. Counsel, I just want to take you back to the issue on direct access and agency. If we deny the applicant direct access, do you not think that that would result in the prejudice of the children and women's rights who are involved in the forceful removals? That is number one. But I want you to deal with it together with the issue of agency. Now, with regards to agency, you have submitted that the matter is not urgent. In fact, you say this agency is self-created. If we do not hear the matter on agency, what is the substantial recourse that the applicant can obtain in due course? And I want you in your response to consider the fact that there are minor children and women who, by the facts, are left stranded with no food, shelter, and water. Please, if you could take us into confidence on why this is not, that we should not consider that to be urgent.
Thank you, Justice. If I got the questions correct, the first one deals with the direct appeal issue. Justice, it is common cause that this court requires exceptional circumstances before a direct appeal may succeed. Now, as I've alluded to earlier, the exceptional circumstance in this case centers, or I could even go put it higher, is solely the homelessness of the community. We then further say the community is rejecting available alternative housing and then come to this court if I can put it this way, on the one hand, the community rejects the available alternative housing, and on the other, the community comes to the court and say, we are homeless, can you please grant us direct appeal? That is the issue that we are raising. Secondly, on urgency, the issue of the absence of substantial relief in the ordinary course is the first hurdle. We lay this out in our heads of argument, where we deal with urgency. And we provide that Mokgalakwena in local municipality, provincial executive council, and Limpopo and others set the complete test for urgency. So the first hurdle would be to prove the absence of substantial redress in due course. But there's a secondary hurdle which this court ought to consider, or secondary factors, and one of those factors is self-created urgency. So you might pass the first hurdle, but if the urgency is self-created, as we suggest in this case, due to the fact that it's the community that is rejecting the available housing, and therefore they are creating the exceptional circumstances that then allows them to come to this court. So they are holding our courts at ransom using circumstances that they create themselves.
Let's use that logic. There are children involved in this matter. These children don't decide anything for themselves. They have not yet created this situation for themselves. How do you ask us to ignore the fact that these children are left without food, shelter, and water? Because, as you suggest, the community has self-created the agency. Are you suggesting that we must ignore the circumstances against these minor children? And I want you to also consider the provisions of Section 28 of the Constitution regarding the best interests of the children. Consider Sections 7 and 9 of the Children's Act, which requires that the court must act in the circumstances where these vulnerable individuals are not able to work for, are not able to answer for themselves. Are you saying, as a guardian of the best interests of the minor children, we must ignore the state?
Thank you, Justice. It is definitely not our submission that the children's rights should be ignored, but the court should frown upon the parties that are directly causing the children to suffer, or causing directly the violation of the children's rights due to the use or with the weaponizing of children in legal proceedings, because this is what we submit it amounts to, because the refusal is blatantly unreasonable, and the only way that we can come to the conclusion is that the refusal is to use then the the homelessness and the children that are involved as a gun to the court's head to admit the applicants for whatever reason that they might. So this court should not ignore, in fact, this court should frown upon the conduct of the respondents, because they are the ones that are putting the children at risk and then using that same risk to appeal to the court.
It seems in your response you agree that children's lives have been put at risk. Am I understanding you well?
Yes, by the applicants.
What should we do with that? Are you suggesting, therefore, there's urgency in that degree?
Justices, I would say no to that answer, because if we admit that there's urgency in that degree, then it would mean that we are saying that the test for urgency does no longer apply, because we would then be saying self-created urgency can then in turn or in another setting turn to real urgency, which means then it will, if this court sets that principle, it will open up the, I would call litigation floodgates, because people will create their own urgency and rely on this court's reasoning, maybe in this judgment, to say, but in that court it was held that self-created urgency where there are children involved can lead to the urgency being actually genuine in order to pass the test for urgency.
This self-creation for urgency that you seem to be submitting is solely based, if I understand you well, on the fact that you are suggesting that the community is rejecting the alternative accommodation that has been provided to them by your client. And you are saying by rejecting that and coming to court to seek a relief as they do, they have created their own agency. But it seems to me that the community's basis for the rejection of the alternative accommodation rides on two legs. One is that they do not want to be away from their ancestral homes, rivers and ravines, because they use that for traditional practices, royal cemeteries, plentiful soil and livestock. That is one. Two, they have said that Mr. Nkopodi had no mandate whatsoever from them to conclude this agreement on their behalf. Are you suggesting that we should ignore these reasons? And these reasons then amounts to the applicants having created their own agency. Is that your argument?
Thank you, Justice. So on the first question, I would submit that the applicants, if the reason is that they do not want to be moved, firstly, the accommodation would be temporary, as I've alluded to earlier, that we are willing to make it available on a temporary basis, provided that the litigation will be ventilated properly throughout the court system. So it's not a permanent solution, because we would like to go maybe back to the consultation phase, but we would like the litigation concerning, because they are very important, complex issues. There's a mineral right, there is informal right, so we feel that we submit correction that the jurisprudence of this court will benefit from the proper ventilation of this matter while the litigants have housing or shelter. Secondly, Justices, it is the same applicants that are alleging a failure by the state to provide alternative housing. The alternative housing that would have been provided with the state would have been far away from the community anyway, because we doubt that the state would provide alternative housing in that remote location at such a short space of time. So they do not want to make use of the relocation settlement agreement, which puts them in a city center, but then they come to the court and saying the government is not providing us with alternative housing, which would have been in the city center or near the city center anyway. So we do not understand that question. In terms of not the question, that proposition. In terms of the second question, it is easy to arrive at that conclusion that there has been a violation if you look at the issue of the agreement in isolation. We submit that this court should have a broader view and look at the conduct of the IAMC from the start, because the IAMC followed all legal avenues and all legislatively required requirements. and then they obtain the mining right. Upon obtaining the mining right, the community then after that settled on the land. When the IMC was ready to mine, they did not rush in and bulldoze the community. They consulted extensively with the community until they were misled by Mr. Nkopodi, who then purported to represent the community. So the IMC in this issue is a very bona fide applicant, and we submit that this court should have a sympathetic view, at least to that element of the case. Not to necessarily say that that makes the agreement lawful, but just to take into consideration the full context of the picture and the bona fide actions of the respondents that led to the end result.
Well, I'm sure your colleagues will come and deal with the lawfulness of that agreement. Thank you very much.
Thank you.
Just before you invited the court not to look solely into the agreement entered into with Mr. Nkopodi. So I just want to check with you. Are you saying to this court, or rather is your submission to this court, that the use of the 8th respondent in this matter was lawful?
The use of the
forceful removers.
The conduct of the 8th respondent.
Yes.
Justice, I would be very disingenuous if I would submit to this court that the removal was lawful. It was unlawful in violation of 26(3), but in rationing out an order and in coming to the judgment, we just seek the court to have a full picture of the conduct of the IMC that contracted with forceful removers, that they have been bona fide up to just that last point where the forceful removers were contracted or asked by the 7th respondent to conduct the removal. Taking into account also that in terms of Section 10 of the MPRDA, the applicants were invited because Section 10 says that the regional manager must advertise in newspapers that is nonetheless my co-counsel will address. But let's just say we will, the full context, not just the isolation of the end result. We submit that this court should have a sympathetic view in rationing the order when it comes to that.
And we must ignore Section 26. Is that what you are saying?
No, definitely not, Justice.
Thank you.
Hey, Councillor, just in closing, I want to find out from you. So is it your submissions that IAMC obtained the license and the rights before the community settled on the land?
Yes, that is a common cause fact. Yeah.
Thank you. That is all. You may call your co-counsel.
I will call my co-counsel, Mr. Fongwaka, to address the court.
Can I appeal that you allow him the 10 minutes? The time was taken by the justices.
Good evening, Justice.
Can I request from all parties, including my colleagues, can we stick to the 10 minutes allocation? I think from the respondent side, only one counsel has made submission. So we'll give you your full 10 minutes. Please try to accommodate arguments and questions in the 10 minutes. Thank you.
Please, the court. Good evening, Justices. My name is Lubabalo Fongwaka. On the matter before the court, I will be appearing on behalf of the respondents. May it please the court, Justices. Justices, taking into account the matter before this court, it is clear that Section 25, subsection 1 of the Constitution, including subsection 2A of the Constitution, is invoked. Justices, these are sections of the Constitution that contains or entails an important features of these two provisions, that in order for the deprivation of a property to be constitutionally permissible, there must be a law of a general application, in which in the matter before the case, we submit that there is a law of general application, and the law of general application in which we relied upon is the Mineral and Petroleum Resources Act Development Act, here under referred to as MPRDA. Further, Justices, if Justices can pay your attention to paragraph 30 and 31 of our heads of arguments, it is clear that Section 2, subsection 1 of the MPRDA embodies the recognition of the country's minerals and petroleum resources to the control of the state. In fact, it vests the control of such in the custodian of the state has its primary objectives. Further, Justices, Section 2B of the same Act, we submit that it gives effect to the principle of the state's custodianship of the nation's mineral and petroleum resources. If due regards could be given to Pengwanyama Yamaswazi and others, Visa's Minister for Mineral Resources and others, and I quote, the court held that, in broad terms, this act seeks to attain its transformation and empowerment aims by making the state the custodian of the country's mineral and petroleum resources, and by placing the control of the exploitation of these resources under the control of the state. Further, Justices, Section 2H states that this section was enacted and promulgated to give effect to Section 24 of the Constitution by ensuring that the nation's mineral and petroleum resources are developed in an orderly and ecologically sustainable manner while promoting social and economic development. Further, Justice, what we have established at this time is that the MPRDA gives custodianship of the minerals to the state and at the same time burden the states with the economic development. Further, Justices, it is a common cause that the IMC, to borrow the phrase from my co-counsel, the IMC obtained a prospective right and mining right after having followed all the legal requirements. And Section 5, subsection 1 of MPRDA provides that a prospecting right, mining right, exploration right, or production right granted in terms of this act is a limited right in respect of the minerals or petroleum in which such right relates. So, Justices, this was confirmed in Agri, South Africa, Visa's Minister for Mineral Resources and Energy. And some of these legal requirements, Justices, are those found in Section 10 of the MPRDA and Section 3, subsection 3 of the regulations of this Act. Justices, I would like to draw the attention of the Court to Section 10, sub 1 of the MPRDA. This regulation invites or makes provision for the invitation to the affected parties to come forward to bring about any objections that they would have in relation to the granting of a mining right. Section 10 of subsection 1 of this Act, I quote, provides that within 14 days after accepting an application lodged in terms of Section 16, 22, or 27, the regional manager must, in the prescribed manner, make known that an application for prospecting right, mining right, or mining permit has been received in respect of the land in question, and called upon interested and affected persons to submit their comments regarding the application within 13 days. Justices, it is clear that taking into account Regulation 3, sub 3 of the regulations of this Act, it is clear that after a to the land in question, or advertisement in local or national newspapers circulating in the area where the land where the land in question is situated.
You have 5 minutes left.
Further, Justices, we submit that all the above requirements were fully met before IMC was granted the mining right. And Justice, further, this implies that the community was made aware of the impending mining operations on the land in question. Therefore, the community did not raise any objection as to when the impending mining operations were made known. Further, we were made known to them. So, in our view, we submit that the silence in objecting to such give rise to an implied consent, is implied consent simply because the applicants in the matter, they should have come, we submit that the applicants in the matter, they should have come forward and dispute the mining rights in question. But in our case before the court, it was never the case. Further, justices, we submit that this is the matter that is about two competing scales, where one is the economic imperative and desirable achievement of resuscitating in ailing economic growth in South Africa through the operation of the country's mineral sector, and the other is the community's right of occupation. Justices, I would like for the bench to take into account that MPRDA provides for a radical departure from our past dispensation in terms of the common law. By issuing or by conferring the state with the power or with the custodianship of the minerals of our country. So, justices, we submit that these two competing scales need to be assessed on the background of the state's empowerment by Section 25.1 and Section 25.1 and 2, and also the conduct of the IMC and the conduct of the community. For that reason, we submit that the community was mollified in its approach in this regard. It ignored calls for representation and only decided to make use of the land in question when IMC had already obtained a limited real right, as it was confirmed in Agri-SA as Minister of Minerals and Energy. Further, justices, when viewing these competing scales, we submit that this given malafide conduct of the applicant and on the other hand, economic imperative which the state seeks to achieve, the removal of the community is in line with Section 25 of the Constitution. Further, justices, Section 25, subsection 1 of the Constitution, we submit that permitted the state to exercise its powers to restrict the owner's entitlement as a state eminent domain. And justices, if you can pay attention to Mkhondwana versus Nelson Mandela and Metropolitan and Nelson Mandela Municipality, the Constitutional Court in this case held that where the deprivation is minimal, a simple rational connection between means and ends would be adequate, and therefore meaning that a governmental purpose would be adequate to expropriate land on behalf or for the benefit of our country's economy. So we submit that, final justices, the deprivation is minimal because the removal of the community comes with an elaborative relocation settlement, as the justices alluded earlier, settlement and the building of a new school. Therefore, justices, we submit that this court must find that Section 25 of the Constitution was complied with, taking into account all the prescripts of the MPRDA. Therefore, I would like to, that would conclude my argument, justices.
Just one question for you, sir.
Yes,
who appointed the removals? Was this done by the state or this was done by a private company?
It was done by a private company, Justice.
Was the private company not accepting the duties of the state, as you have just referred us to Section 25 of the Constitution? Who is empowered in terms of the Constitution to expropriate land?
In our submission, justices, they are empowered, but their empowerment does not rely solely or directly. They rely through the Minister of Energy, as the one who's exercising the public authority. So IMC as a private entity does not have such power.
Do you have any questions? My colleague has one question for you.
Counsel, I just want to refer you to Section 26 of the Constitution. Subsection 3 thereof states that no one may be evicted from their home or their home demolished without an order of court made after considering all the relevant circumstances. Did your client have a court order before forcefully removing?
The answer to that, no, Justice, is no.
Thank you.
Do you have a question? You are excused. You may call your last colleague.
Thanks. Justices, if I may not be of no further use of the court, then I would like to invite my co-counsel, Mrs. Museke. It is the court.
Good evening, Justices. I am Violetu Musoge, appearing in this matter on behalf of the respondents, and I will address two substantive issues, which is the issue of the protection of the children's rights and the admission of Save the Culture as amicus curiae. May it please the court, I will begin with my submissions. Justices, the applicants came before this court and correctly stated that the Constitution guarantees children to the right to basic nutrition, shelter, basic health healthcare services and social services. And they spoke to the best interests of the child principle that is found in section 28, subsection 2 of the Constitution. Before I move on to plead my case, I'd like to refer the justices to paragraph 85 of our written submissions, and I'd like to quote something that was held in the McCall versus McCall case, where the court held that when it is tasked with determining the best interest of the child principle, the court is not adjudicating a dispute between the antagonists with conflicting interests to resolve their discord. The court's concern is for the child. Justices, the applicants have come before this court and they have argued that it is the respondents who acted not in the best interest of the child, but we put it to the court that it is the applicants who acted in conflict with the best interest of the child principle. Justices, the applicants have not attempted or even considered to attempt the prospective benefits that this company will bring to the children of this community. When the respondents concluded the negotiations with the applicants under the bona fide impression that they had obtained the required consent, one of the commitments in the elaborate resettlement agreement was to build a school for the blind, which will be of great benefit to the blind children of this community who are currently without access to formal education. This is in line with Section 7, subsection J of the Children's Act, which states that whenever the best interest of the child principle is to be applied, one of the factors that must be considered is any disability that that child may have. Justices, the significance of this commitment to build a school for the blind must not be viewed lightly. The importance of education was best characterized in the case of Center for Child Law and others versus Minister of Basic Education and others, where the court held, and I quote, "Today, education is perhaps the most important function of the state and local government. Compulsory school attendance laws and great expenditures for education both demonstrate our recognition to the importance of education and our democratic society. It is required in the performance of our most basic public responsibilities, even in the armed services." And they held very correctly, judges, that it is education is the very foundation for good citizenship. We submitted as the respondents that the respondents are giving the children who are visually impaired or differently abled in this community a good foundation for good citizenship, and that they may contribute to the functioning and the economy of this country in the future. In the case of JSH versus MSH and others, which is a recent case, a mother was suing her estranged husband for fees of a private school. The respondent in that case proved that he could not afford the means for that school, but he had found a suitable alternative. The applicant dragged the litigation process, and the Western Cape High Court correctly held that Mrs. H's refusal to consent to the enrollment of her children into any other school other than ours has resulted in the children not attending a school at all. Therefore, her conduct in this regard is unreasonable and manifestly not in the best interests of her minor children. Similarly, justices, in the elaborate resettlement agreement, and I know my co-counsel have emphasized that it includes alternative housing, but if you see the state of facts, it says inter alia alternative housing. So that is not the exhaustive list of the commitments that the respondents are willing to give. Similarly, the respondents have invested in adequate or alternative adequate housing in the city center, and the children currently missing out on instructional time at school now is a result of the applicants refusing to, at least on an interim basis, utilize this alternative accommodation or housing. This, as was decided in the above case, should be viewed by this court as unreasonable and manifestly not in the best interest of the children of this community. Justices, it is common cause that the unemployment rate in the Eastern Cape is high, especially in remote areas such as the land in question. According to the Eastern Cape Socio-Economic Consultative Council, the unemployment rate in the first quarter in the Eastern Cape was sitting at 40%. Justices, this is by no means legally binding authority, but we want to use it in this court as persuasive authority. This is why the respondents are willing to give the community members in this community, as part of the settlement agreement, first preference when it comes to jobs at the mine. And this will also benefit the unskilled members of this community that can be trained in-house. This would mean that that the parents would be in a better position to provide for the basic rights of their children, such as nutrition and healthcare, due to the medical benefits that will come with these jobs. When it comes to the children's rights in section 28 subsection 1, namely to nutrition, shelter, basic healthcare services, social services, the location alone of the city centre justices provides much better access to that. You'll find it in paragraph 91 of our written heads. The land in question, justices, is a common cause that it is in a remote area, meaning that these children currently have to travel long distances to access schools, recreation facilities such as libraries, clinics, hospitals, and social services. So their access is limited based on the remoteness of this land. We'd like to leave this court with the following question. Have the parents considered instances where their children will get critically ill in the middle of the night and will be in need of urgent care if they remain in this remote location? Moving on to Save the Culture as amicus before this court, we do not contest the procedural manner in which this court will admit this NGO, as has been alluded by the applicants. Justices, we do contest the merits, though, of Save the Culture coming here. We submit that there is no value that Save the Culture will have or bring to this case as amicus curiae. The community within its ranks already has cultural experts who are seasoned in matters relating to the advocacy for the rights of traditional healers. These people include a third applicant who is a Nyanga in Sangoma with more than 20 years experience and has been trained by the fourth applicant who is Gogo Mtembu. The cultural knowledge that this NGO purports to bring is purely research and academic related. Why would this court benefit from their inputs when they have one better? The lived experiences of the applicants in this party. Justices, it is common cause that this court does not merely admit amici who have no new contentions to matters before this court. And this was confirmed in National Treasury and others versus the opposition of Urban Tolling and Alliance and others, where the court held that it is insufficient for a prospective amicus to simply echo the position of the party with slight variation, and cited that if its contentions are not new, then it should not be admitted as an amicus. We believe that there is no better people who know about the cultural practices and who can advocate for their cultural practices than the applicants themselves. So this NGO will add no value. In conclusion, justices, this case presents a profound clash between the imperatives of economic growth and the preservation of constitutional rights. This court's decision will not only determine the fate of the applicants, but will also set a precedent for balancing economic development with the rights resonating beyond this case. Justices, we need to consider that the respondents here, should they be allowed to continue to mine on this land in question, are going to contribute towards a sector that contributes 8% of the GDP of this country, and specifically towards an ailing economy of the Eastern Cape, where the unemployment rate is the highest. The praise of the respondent before this court are as follows: that the application be dismissed on the basis of urgency and of direct appeal, because we are of the view that the applicants have not made their case, and we require no order as to the costs.
Thank you, Counsel. I do not have a question for you. I'm not sure if my colleagues have.
Counsel, I just want to check with you. Is it your submission that the school that is going to be built for the benefit of the community, do you not think it will be for Mr. Nkopodi himself who will be the beneficiary because he wants to be the director?
Thank you very much, Justice, for that question. Be that as it may, if Mr. Nkopodi's intention were ill, it doesn't take away from the fact that whether he is the director or not, the existence of such a school, in an instance where it didn't exist, will still benefit the children of this community. So it is a consideration, and it's ill-informed of Mr. Nkopodi, but the existence of the school itself, it's undisputed that it will indeed help these children, and we cannot take away from the fact that they need it.
Thank you. And then just the last one. You submitted to this court that education for children is of paramount importance. Do you not think that the relocation will be disrupting their education at the time?
Thank you, Justice, for that question. On a temporary basis, yes, but we asked the court, as was requested in the McCall versus McCall case, to perhaps we want to illuminate the benefits that would come with the relocation to these children, to the children of this community in the short term and in the long term, because education is tied with healthcare services, social services. Holistic education includes recreational centers such as sports facilities and libraries, which are in aid of education. And so the education that they are receiving now is maybe a formal one, but at the Sinti Center they will have a more holistic education system that is going to include sports, that will include libraries, that will include internet, and a lot of other things that are part of a holistic education system in 2024.
So your submission to this court is that all the schools in the city centers provide that which you are submitting?
It is not my submission to the court that all the schools, I cannot definitely say that. I do not have the facts to support that. However, it is my submission to this court that the access to these facilities is on Common Cause much lower in a remote area in the Eastern Cape. Thank you.
Thank you, Counsel. You are excused. The applicants will be awarded 5 minutes in rebuttal.
As it pleases the court. It was submitted that the respondents do not see the exceptional circumstances in regard to the urgency of this case, in regard to the direct access of this case. Yet, the people are losing their land, and it has been their land for over 200 years. The respondents have totally disregarded the fundamental human rights of this community. The respondents totally disregard the requirements as set out by the MPRDA in regard to the notification and consultation of the affected parties. The refusal of housing is because the community has ancestral ties to land and they earn a living because of the land, and they use said land for their cultural practices. It is also submitted that the community comes to this honorable court and allege that they are not being provided adequate alternative housing, but the community would not have needed that said alternative housing if they have not been forcefully removed from the land. The MPRDA Act does not allow unlawful eviction of occupiers from the land. There should still have been a court order issued in regard to this. The respondents are also submitting that the government is custodians, yet nowhere that is a given fact. Thus, they are implying that this matter is expropriation and not deprivation of land. The respondents are also disregarding the fundamental human rights of the community, and this court should only regard the respondents are submitting that they are disregarding the fundamental human rights of the community, and that the court should only regard the economic gain of the country. It is also thus submitted that they acquired consent when they acquired the consent from the ACC, or rather Mr. Nkapodi, when they became aware of the unlawful consent, that they still unlawfully evicted the community from the land without a court order. The respondent relied on the limitation of rights on the basis of general application, but that is only when it is reasonable and justifiable. The applicants do not think that it is reasonable or justifiable that the community be left without shelter, food, or water in that matter. As it pleases the court, we conclude this matter.
I just have one question for you based on what the applicant submitted. If you check paragraph 2.4, read with 2.3, it seems that according to the respondents, IMC had obtained the license much earlier than this community resettled in this land. Is that your understanding as well?
No, that is not our understanding. Our understanding is that the community has been living in the Bukang region of the Eastern Cape for over 200 years.
Thank you, Council. I'm not sure if there's a question from my colleagues. Thank you, Court Agents. Yeah, we need to finish. Then I have to be at the soccer now. The child that I was with. But are you done with your score sheets? Yeah, I know. I'm happy Lena this time you did. Okay. They did well.